All right, 55th Circuit Court is now in session. The Honorable Thomas R. Evans.
Good morning, you may be seated. Did you want to do the Houston matter first?
If you'd like, I need to get, Judge, I need to get my lap.
Sure.
Leave it up.
I'll bring in Mr. Mason.
Calling the cases of People versus Kenneth James Husted, file numbers 19-6244 and 20-6522-FC. Would counsel identify for the record, please?
Morning, Your Honor. Mark Webb on behalf of the people.
Please, the court, Scott Moore for the defense.
And sir, are you Kenneth James Husted?
He's still unmute. I've asked him to unmute, but I don't know if he has control or if somebody else does.
Thank you.
Mr. Houston, you need to unmute your microphone, please.
I will in just 30, there you go.
There
Is
we
it there
go.
now?
Yep, we
I don't
hear
have
you.
the remote, I just had to wait it out.
Are you Kenneth James Husted?
Yes, Your Honor.
Previously, Mr. Husted, back on April 6th, 2021, you appeared in court and in file 19-6254-FC, you pled guilty to possession of methamphetamine and to being a habitual offender, second offense notice. You appear here today to be sentenced. The maximum penalty the court normally could impose for possession of methamphetamine would be 10 years in prison, and the minimum sentence would be discretionary with the court. However, because you also were convicted of being a habitual offender, second offense notice, the net effect of those things is that the court in its discretion may increase the maximum sentence from 10 years in prison to 15 years in prison. It would be discretionary with the court whether or not to do so. And regardless of what increase the maximum end of the sentence, the minimum end of the sentence still would be discretionary with the court. You understand those things, Mr. Husted?
Yes, Your Honor.
Now in file 20-6522-FC, back on or about April of 2021, you appeared in court, and in that file, you pled guilty both to delivery or manufacturing of a Schedule 1, 2, or 3 controlled substance other than cocaine or methamphetamine or ecstasy or marijuana. And you also pled guilty to second or subsequent offense notice under the Michigan Controlled Substance Act. The net effect of things is that ordinarily the maximum penalty the court could impose would be 7 years in prison. However, when coupled with the conviction for the earlier violation or conviction under the Michigan Controlled Substance Act, the second or subsequent conviction, the net effect of those things is that the court in its discretion could double the maximum penalty from 7 years in prison to 14 years in prison. In that same file, 20-6522-FC, you also pled guilty to possession of a controlled substance analog and to second or subsequent conviction under the Michigan Controlled Substance Act. Possession of a controlled substance analog is punishable by a maximum penalty ordinarily of 2 years in prison, and the minimum sentence ordinarily would be discretionary with the court. However, because you also were convicted of second or subsequent conviction under the Michigan Controlled Substance Act, the net effect of those things is that once again, the court could double the maximum penalty in this circumstance from 2 years in prison to 4 years in prison. It would be discretionary with the court whether or not to increase the maximum end of any of these sentences. And regardless of whether the court does so, the minimum end of the sentences would be discretionary with the court. Do you understand those things, Mr. Houston?
Yes, Your Honor.
Now, the Clare County Circuit Court Probation Department and the Michigan Department of Corrections have prepared a pre-sentence investigation report and sentencing information reports as well. And in those reports, at least thus far, they calculate your applicable sentencing guideline range in the 2019 file to be 19 to 47 months. And in the 2020 file, they calculate your applicable sentencing guideline range to be 19 to 38 months. So in the 2019 file, 19 to 47 months. In the 2020 file, from 19 to 38 months. Although, according to the Michigan Supreme Court in People versus Lockridge, those guidelines now are advisory instead of mandatory. Mr. Moore, have you gone over these reports with your client?
Yes.
Is there anything in any of the reports of a factual nature that you want to add to or explain or contradict?
Okay.
Do you have any challenges to the scoring of the offense variables or the prior record variables or the calculation as to the applicable sentencing guideline range in either of these two files?
I have no challenges, Your Honor, but I would like the record to reflect that Agent Brubaker and I have gone through scoring. I agree with her calculations, which are below the cap that we had agreed to. And the reason why we went forward with this, because that was pretty close to what I imagined it would be. My client has already been sentenced to a 72-month sentence from Ogama County. He's facing federal time. And we are asking for concurrent sentences on both files. So while the agreed upon term of incarceration in this case is somewhat higher than what is recommended by the department, all in all, it seemed as if my client were getting the benefit of the bargain. I just want that to be clear with what my thinking was. Proceed on that basis. So no challenge, but we do recognize that it's lower than that. Thank you.
Thank you, sir. And Mr. Webb, on behalf of the people, I would pose that same series of questions to you.
Thank you. I've reviewed the reports, have no additions or corrections to make to them. And I reviewed the scoring guidelines and believe those are also accurate.
Thank you, sir. Mr. Husted, is there anything, sir, you want to say on your own behalf before the court passes sentence?
No, Your Honor. No,
Thank you, sir.
just,
And
I
on behalf-
asked that you run it concurrent because of the time I'm already doing, and I do have, I'm waiting on to federal case. I'm not sure if I have it or not, but I do ask that at the time, please gets run concurrent.
All right, thank you, sir. And on behalf of your client, Mr. Moore?
Thank you, Your Honor. We ask the court to ratify the Briggs-Killebrew agreement in this case and to adopt the recommendations. We're not inconsistent with that agreement. As the court is aware, my client is indigent. He has been sentenced to serve a significant period of time. The fines and costs, while generally speaking are not unfair, are going to work a great hardship on him. As the court knows, my client has already posted $4,000 in cash money in his own name to be applied to fines and costs. However, he has approximately an equal amount of money due and owing to the county, as well as fines and costs on his other matters. So we would ask the court to postpone payment of whatever my client's release. Finally, and this is separate from the actions before the court today, but I indicated to my client that I would make a record of this. There was a brief conference in chambers regarding the collateral forfeiture action. Mr. Webb very graciously entertained my messages from my client, where Mr. Husted contends that he did file a challenge to the forfeiture, or at least presented a challenge to the sheriff department to deliver on his behalf to the clerk's office. It's unclear whether that was received by the clerk. And by way of substantive defense to the forfeiture action, Mr. Husted claims that he sold a motor vehicle to one Lonnie Adsit. There was a bill of sale executed. A copy of that should have been left with the vehicle. Apparently, Sheriff Wilson looked into it. That might not have been obtained. However, Mr. Adsit would have a copy of that as well as the vehicle itself. I'm stating this merely so that there is a record of it. I trust that Mr. Webb and the prosecutor's office will work in good faith with Mr. Husted as regards the forfeiture. So once again, Your Honor, we do ask that you follow the Briggs-Killebrew agreement and adopt the recommendations. We're not inconsistent with my allocution. Thank you.
Thank you, sir. Before we proceed further, and I apologize, this is a little bit disjointed, but there was one small typographical error that the court noted in two places in the report. On page 1 of the CFJ 145, there's a reference to file 20-6552-FC. That should be file 20-6522-FC. And similarly, on page 1 of the CFJ 284, there's a similar reference to file 20-6552-FC when it should be file 20-6522-FC. The court will make those corrections and direct the department to do so as well. I apologize for interrupting you, Mr. Moore.
Oh, not at all, Your Honor. In fact, there wasn't, and then you interrupted me, which was great because now I remembered. Agent Brubaker spent a lot of time computing time served, and I worked with her, at least we discussed her calculations. I believe they're correct. There's a substantial statement as to how that number was arrived at. If it is incorrect, I'm sure it can be taken care of at a later time, but we have no objection to the time served that's been calculated by the department.
Thank you, sir. And on behalf of the people, we've heard from the defendant, we've heard from the defense attorney as far as elocution, is that correct?
Yes, Your Honor.
Thank you. And elocution by the people, Mr. Webb?
Thank you, Your Honor. As you're probably well aware, and you're probably pretty familiar with this defendant, he's got 12 prior misdemeanors and 10 prior felonies. I think these sentences that have been agreed to in these cases are appropriate. And I ask you to follow the plea agreements and the recommendation.
Thank you, sir. Mr. Husted, you certainly are still a relatively young man. You can certainly make a life for yourself, but ultimately that's going to be up to you. And you're going to be in the state's prison for a period of time. And from what you've said, even in the federal prison for a period of time. In order to punish you for what you've done and to deter you and others from committing crimes in the future, but also to give you the chance to rehabilitate yourself in file 19-6454-FC for the conviction of possession of methamphetamine plus habitual offender second offense notice. It's the sentence of the court that you be committed to the Michigan Department of Corrections for not less than 14 months and not more than 15 years. In addition, in file 20-6522-FC for the convictions of delivery or manufacturing of a Schedule 1, 2, or 3 controlled substance other than cocaine or methamphetamine or ecstasy or marijuana, plus a prior conviction under the Michigan Controlled Substance Act. It's the sentence of the court. You be committed to the Michigan Department of Corrections for not less than 47 months and not more than 14 years. For in that same file for the conviction for possession of a controlled substance analog plus a prior conviction under the Michigan Controlled Substance Act, it's the sentence of the court that you be committed to the Michigan Department of Corrections for not less than 32 months and not more than 4 years. All three of these sentences will run concurrently to one another. They all will run at the same time, although in the 2019 file, you are only entitled to 10 days credit for time served. In the 2020 file, for each of those two sentences, you are entitled to credit for 130 days previously served. In addition to the prison time, it also is the sentence of the court. You must pay $204 in state costs, representing $68 for each of the 3 felony convictions. You must pay a crime victims assessment of $260, representing $130 in each file. You must pay court costs of $1,000, representing $500 in each file, and you must pay a fine of $1,000, representing $500 in each file. And with regard to court-appointed attorney fees, do you have an estimate, Mr. Moore?
I do, Your Honor. $780, because there was a great deal of overlap in these cases, we would ask the court to assess $390 in each case.
Very well, then, court-appointed attorney fees of $390 in each one of the 2 cases for a total of $780. Your bond will be canceled. You will be remanded to the custody of the sheriff and ultimately to the Department of Corrections for carrying out of the sentences. Each of the sentences will run concurrently to one another Each of the sentences will run concurrently to any other sentence you currently are serving, to the extent that that's possible, which I think it is possible. And finally, with regard to any sentences that are imposed later by another court, I really don't have the power to make these sentences consecutive to any such sentence from another court imposed later, but I certainly have no objection to it. It's my duty to inform you, Mr. Houston, that you are entitled to appellate review of your convictions and sentences, and if you are financially unable to hire a lawyer, then the court will appoint a lawyer for you and will furnish that lawyer with the records and the transcripts that are necessary to perfect an appeal. But a request for the appointment of an attorney must be made within 42 days of today's date in writing and sent directly to the court. Finally, the record should reflect that the court is well aware it's discretionary with the court whether or not to enhance the maximum end of each of these sentences. And the court believes it is appropriate to enhance each sentence's maximum end, considering all the circumstances of the two cases and the defendant's prior record, among other things. Thank you, sir. Good luck to you, Mr. Houston.
Thank you, Your Honor.
You're welcome, sir.
We have Mr. Mansfield.
Okay.
Well,
Calling the case of People versus Edward Elwin Mansfield, file 18-5855-FH. Would counsel identify for the record, please?
And please, the court's got more for the defense.
I'm sorry.
It's
Mansfield, it's a probation violation matter.
I'll help Ms. Brubaker if she needs it, Your Honor.
Thank you. Appearing on behalf of Agent Caitlin Brubaker appears on behalf of the Probation Department and the Department of Corrections. Mr. Webb appears on behalf of the People. And today is the date and time scheduled for a hearing or an arraignment. How did you want to proceed in that regard, Mr. Moore?
Thank you, Your Honor. Today was scheduled as a status conference. I believe we are prepared to end the week.
Oh, thank you, sir.
In any event, I'm at a bit of a stand here. Mr. Mansfield had posted bond some time ago. We did speak on the telephone yesterday. My understanding is that the amount of money that he posted to cover the delinquent fines and costs, as it would affect the case, and because I have not received an offer from the Department of Corrections on this, as I say, we could plead today and have an update, but I want the court to be aware that I will be asking for my client to be discharged from probation, successfully or unsuccessfully, if in fact all fines are paid.
Mr. Webb and Ms. Brubaker, do you have any position in that regard?
I'll defer to Ms. Brubaker.
I'm sorry, Your Honor, what was your question?
Well, Mr. Moore seemed to be indicating, and first, before we proceed further, is this going way back to the April of 2020 charging document?
I believe it is, Your Honor. I don't think I've got anything more current than
Okay.
Mr. Mansfield lives in Kent County, and the supervision has been spotty at best, and then the public health emergency that we've all had to labor under. It's taken quite some time for this to get here. And since that time, it's now a technical violation all the way around. My guy
The judge muted me.
Oh, no, he didn't. We can hear.
Oh,
all of it.
Oh, no, it's fine. It looked like it was muted. I'm sorry, Your Honor. I was talking to my wife.
All right.
In any event, Your Honor, this is a technical violation, and I think the main thing is to confirm that he's actually paid everything up. We're not putting a defense for failure. We'll admit to that, but we think that the defect has been cured. And given all of the time that he's been on probation as such, we think it's time to end this case. Thank you.
And I don't know if you could hear all of that, Agent Brubaker, but basically, the defense attorney, Mr. Moore, was indicating, I believe, that the defendant was prepared to plead guilty to count 1 and 2 of the probation violation charges from April 8th of last year, 2020, but that he's of the position that all of this money has since been paid, and he would like to be discharged from
I have no objection to that, Your Honor.
All right, the clerk of the court has handed to me a note to the effect that in the 2018 file, the file 18-5855, which is the file that he's technically here on today, that owes $1,239.60. He has a bond of $2,500, which could theoretically be applied towards that amount. In the 2014 file, he owes $1,297.60, and there is no bond applicable or available to be applied in that file. Do you have any response in that regard, Mr. Moore?
Those numbers tally substantially with what my client indicated to me yesterday, and I'm sure he would have no objection to anything left over from the current bond be applied to the earlier 2014 case.
Is that true, Mr. Mansfield?
Yes, Your Honor.
Thank you, sir.
So as my back of the envelope calculations would suggest that there will be a slight arrearage, something under $50 for him to pay. And I've indicated that he would have to make that payment right quick, no later than the end of this week.
Will you be able to do that, Mr. Mansfield?
I think yes. My advice to you, Mr. Mansfield, is yes would be the very best answer you could give.
Yes, I could do my best to pay it off at the end of the week, Your Honor.
$37.20, Your Honor, will be his balance.
Okay, that would be $37.20, sir.
$37.20, okay.
Yes, sir. Can you pay that by the end of the week?
Yes, I can. I'm not gonna lie, I get a $42 check Wednesday. I could pay it Wednesday.
Then by the end of the week.
Yeah, but I could have it by Wednesday regardless. Yes, I could pay it by the end of the week.
Government never turns away money, so pay it whenever you can.
There you go.
All right, thank you, sir. Agent Brubaker, do you have any problem with the defendant being discharged unsuccessfully from probation upon payment of this money?
No, Your Honor. Thank you.
Thank you. Mr. Mansfield, would you please raise your right hand to be sworn, sir?
Yes, sir, I will.
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Could you tell us your name, sir?
Edward Elwin Mansfield Jr., preferably Eddie.
Okay, Mr. Mansfield, Do you understand that you currently are on probation to this court in this file?
Yes, Your Honor.
Do you understand that you currently are on probation for attempted failure to comply with the Michigan Sex Offender Registration Act, which is a 2-year crime, carries a maximum penalty of 2 years in prison?
Yes, I understand.
As a consequence, if you plead guilty to violating your probation, or if you're found guilty of violating your probation, then the maximum penalty the court can impose would be 2 years in prison, and the minimum sentence would be discretionary with the court. Do you understand those things?
Yes, I do, Your Honor.
Do you understand that according to count 1, it is alleged that you did violate special conditions 8.4, 8.5, and 8.6 of your probation order relating to court-ordered monies to be paid? And specifically, it's further alleged in count 1 that as of March 12 of 2020, you have only paid $595 of the $2,034 that was ordered paid. Do you understand count 1?
Yes, I do, Your Honor.
Do you understand that according to count 2, it is alleged that you did violate special condition 9.70 of your payment plan, which required you to pay at least $150 per month? And further, it's specifically alleged that as of March 12 of 2020, you have failed to comply with your payment plan. Do you understand count 2?
Yes, I do, Your Honor.
With regard to count 1 and with regard to count 2, you may make any of the following 3 pleas. First, you may plead you're guilty, but don't plead guilty unless you are guilty. Second, you may plead not guilty. And third, you may stand mute and say nothing, in which event the court would enter a plea of not guilty for you. Do you understand the 3 possible pleas you may make to count 1 and count 2?
Yes, I do, Your Honor.
In answering to count 1, what is your plea?
I plead guilty on both.
Okay.
By my own admission.
All right, so you plead guilty to count 1, is that true?
Yes, Your Honor, and I plead guilty to count 2.
And do you also plead guilty to count 2, sir?
Yes, Your Honor.
All right. Do you understand no one can make any promises for me about what your sentence will be?
Yes, Your Honor, I understand.
The court also informs you that if your pleas of guilty are accepted, then that means you won't have a hearing of any kind, and you therefore would be giving up each and every one of the following rights. The right to have a contested probation revocation hearing, the right to be represented by a lawyer, and the right to have a court-appointed lawyer if you are financially unable to hire a lawyer, the right to appear at that hearing and to present evidence and to cross-examine witnesses, the right to require the probation agent or the prosecutor to prove by a preponderance of the evidence that you did violate your probation as alleged, the right to remain silent and to not have your silence used against you. But on the other hand, you also do have the right to testify at the hearing. And if you choose to do so, then your testimony would be considered in the same manner as the testimony of any other witness. Do you understand all of these rights, Mr. Mansfield?
Yes, I do, Your Honor.
And do you understand that by pleading guilty, that means you'll be giving up each and every one of these rights?
Yes, I do, Your Honor.
Now, has anyone promised you anything to get you to plead guilty?
No, Your Honor.
So for example, has anyone promised you that if you plead guilty, that this court then would be lenient or light on you in any way?
No, Your Honor. Nobody promised me anything. It's by on my own
Is any-
admission.
Has anyone threatened you or your family to get you to plead guilty?
No.
Is it your own personal choice to plead guilty? And are you doing so freely and voluntarily?
Freely and voluntary, Your Honor.
Now, do you have any questions about what the court has told you?
No, sir.
Do you understand everything that the court has told you?
Yes, I do, Your Honor.
Now, in light of everything that the court has told you, do you still want to plead guilty to count 1 and count 2?
Yes, Your Honor. I want to plead guilty.
Sir, drawing your attention back to about 2.5 years ago to December 17 of 2018, did I sentence you in this file, in this case?
Yes, she gave me 18 months probation and then extended it for a year because I wasn't paying my fines. I was doing the best I can until my payee started taking my money. Now I became my own payee. I was struggling.
Now, did I make it a condition of your probation when I sentenced you in December of 2018 that you were required to pay $2,034 in court-ordered monies?
Yes, Your Honor.
Did I also make it a condition of your probation when I sentenced you that you had to pay at least $150 per month towards your court-ordered monies?
Yes, Your Honor.
Is it true, sir, that as of April 8th of 2020, about 14 months ago, that you had only paid less than $600 of the $2,034 that was owed?
Yes, Your Honor. Due to the payee situation, I agree.
Okay.
Yes.
Is it also true that as of March 12, 2020, you had failed to comply with your monthly payment plan?
Yes.
Very well, then, are you satisfied there's a sufficient factual basis to accept the defendant's pleas of guilty to counts 1 and 2, Mr. Moore?
Yes, Your Honor.
Do you agree, Mr. Webb and Ms. Brubaker?
Yes, Your Honor.
Very well, then, you want to go ahead and be sentenced. Does your client wish to be sentenced today and give up his right to have an updated probation violation report prepared, or does he want to go ahead and come back at a later date to be sentenced, Mr. Moore?
Thank you. After discussing this with my client, who would the updated probation violation report as per immediate sentencing.
All right. The maximum penalty the court could impose is 2 years in prison. The minimum sentence is discretionary with the court. The applicable sentencing guideline range is 0 to 17 months, although according to the Michigan statutes, the maximum sentence the court could impose in this situation would be 16 months on the minimum end and 24 months on the maximum end in any event. Is there anything you wanted to say on your own behalf, Mr. Mansfield, before the court passes sentence?
No, Your Honor.
And those guidelines, of course, are advisory instead of mandatory. Is there anything you want to say on your behalf of your client, Mr. Moore?
Thank you, Your Honor. I would ask the court to recall what I had said earlier when placing our desires on the record and discharge my client unsuccessfully from probation with the understanding that he is to pay $37.50 by the end of this week.
Thank you. And on behalf of the department and the people, Mr. Webb,
I have nothing to do, I think.
anything further, Ms. Brubaker?
Nothing to add. Thank you, Your Honor.
Very well then, sir. In order to punish you for what you've done and to deter you and others from committing crimes in the future, but also to give you the chance to rehabilitate yourself, it's the sentence of the court. You'll be continued temporarily on probation until you have paid all of your court-ordered money in these two files. You must pay all the court-ordered money you previously were ordered to pay, and according to your agreement placed there on the record, your bond will be applied towards the outstanding balance in each one of these two files, and you must pay any remaining balance by the end of this week. I will then discharge you unsuccessfully from probation. I'm not going to give you any additional jail time today. Thank you, sir. It's my duty to inform you that you are entitled to appellate review of your conviction and sentence. And if you're financially unable to hire a lawyer, then the court will appoint a lawyer for you and will furnish that lawyer with the records and the transcripts that are necessary to perfect an appeal. But a request for the appointment of an attorney must be made within 42 days of today's date in writing and sent directly to the court. Bond is canceled. Any bond posted in the defendant's own name will be applied towards court-ordered money.
I have one question real quick. Do I have to pay $37 and some change by the end of the week and I'm done?
Yes, sir. Now,
All right, thank you, Your Honor.
what is your address?
4495 28th Street, which is room 350. I live in a hotel.
And what city is that in, sir?
Grand Rapids, Michigan,
Thank you.
49312. Or excuse me, 49512.
Thank you, sir. Make
You're
sure
welcome,
you
Your
send
Honor.
in that money before the end of the week. Thank you, sir. And
Thank you. You guys have a blessed day.
Anything further, Mr. Moore?
No,
Thank you. Thank you, sir. You're free to go if you would like then, sir.
All right. Have a nice day, Mr. Moore. Have a nice day, Mr. Judge Evans.
Thank you, sir. Good luck to you.
thank you.
God bless. Yep. Good luck.
You too, sir.
Your Honor, I understand that one simple country lawyer's problems don't amount to a hill of beans. However, I am scheduled. Oh, by the way, thank you for your innocence there. That could have gone very poorly. Thank you for your patience.
Oh, that's
He needs one. Now, about me. I am supposed to be in front of Judge Farrell at 10 a.m. I did advise them that this was motion day, and they will give us time. It's just I noticed that Mr. White was on the screen a few moments ago. I have two people who are in the Gladwin County Jail. And I think I have a couple of no-shows that we can fly through. So if you could, Your Honor, maybe put the Gladwin cases off and then do the no-shows.
Sure, that's fine. by
Yeah, we
me.
don't have
Any problem,
anybody.
Mr. Webb?
I'm sorry, Judge, I do have a telephone number on here I have not identified yet, and I want to make sure that that's not one of Mr. Moore's clients before we go through the rest of them, if that's okay.
All right, and then you feel free to attend to this.
Good morning, could you please unmute your microphone? Telephone number ending in 980.
Corey Briggs.
Okay, Mr. Briggs, I'm gonna place you back into the waiting room, and as soon as it calls your case, I will bring you back in, okay?
Okay.
Thank you.
Thanks, Mr. Moore. Good luck to you.
If you'd like, Your Honor, we can call a couple of cases before I go, but I don't think they're going to be here. Or I can do them all
Oh,
later.
okay, sure. If you.
Oh, it's
might as
just
well get-
district court, Your Honor. I mean, my goodness.
Might as well get them out of the way. Which ones would you like called, sir?
Let's start with Dominic Tyler, Your Honor.
Calling the cases of People versus Dominic Ryan Tyler, file numbers 2021-6652 and 6655-FH. Would counsel identify for the record, please?
Sherman Presides, appearing on behalf of people.
May it please the court, Scott Moore for the defense.
Mr. Tyler was ordered to be here about an hour and a quarter ago at 9:01 a.m. It's now 10:14 a.m. by the court's clock. Mr. Tyler apparently has failed to appear. His lawyer was here in a timely manner, as was the prosecuting attorney. Do you know of any reason why Mr. Tyler is not here, Mr. Moore?
I might, Your Honor, although I'm fain to commit to it too hard. Mr. Tyler posted bond on June 1st. My office did not send the notice to appear to him until June 4th after he had left. Against that would be the fact that today's date was announced on the record in district court when the case was bound open after the preliminary examination was made. Further, we have no record of any contact with Mr. Tyler since he has left the sheriff's department. So there at least is a colorable argument that we did not receive actual written notice of today's hearing. And in any event, wouldn't be relying on the recently revised court rules and statutes. And ask the court to set this for a show cause hearing whenever the court feels is appropriate. Thank you.
Thank you, sir. Very well, then we'll order the defendant Tyler to appear in person on Monday, June 21, 2021 at 9 a.m. and to show cause why he should not be held in criminal contempt of court and violation of his bond for failing to appear here today. The record should reflect it's 10:16 a.m. by the court's clock. Thank you, Mr. Moore.
Thank you.
Was there another matter you wanted to address?
Randy Bowen, Your Honor.
Calling the case of People versus Randy Lynn Bowen, file 21-6637-FH. Would counsel identify for the record, please?
Sherman Presides, appearing on behalf of people.
May it please the court, Scott Moore for the defense.
Ms. Bowen had been ordered to appear here in court previously to be arraigned back on May 17 of 2021, at which time she failed to appear. The court then scheduled a show cause hearing to be conducted today at 9:01 a.m. It's now 10:17 a.m. by the court's clock, more than an hour and a quarter past the scheduled time. Ms. Bowen has failed to appear. Do you know why that is, Mr. Moore?
I do not, and I'm on firmer ground with this case than the last one that the court called. On May 18th, 2021, my office sent a notice to appear for the show cause hearing as well as the arraignment. That mail has not been returned to my office. We sent a text message as a reminder, my cell phone number for consultation over the weekend, sent that out Friday at 4:14. Finally, we emailed a copy of the notice to appear at the last known email address for Ms. Bowen on June 4th, 2021, Friday at 3:51. So I have no explanation.
Thank you, sir. Very well, the court will revoke and forfeit the defendant's bond issue a bench warrant for her arrest, for her to be brought before the court to show cause why she should not be held in criminal contempt of court for failing to appear here today. Bond on the bench warrant is set in the amount of $3,000, cash only, to be posted only in the defendant's own name. The record should reflect it's 3:18 a.m. by the court's clock. Ms. Bowen still has failed to appear.
I think that's all I need to cover at the moment, and I would give way to Mr. White. Your Honor. Thank you.
Thank you, Mr. Moore. And Mr. White, do you have a preference about what order to take your cases in, sir?
I don't believe so, Your Honor. I believe Mr. Briggs is available at the present time.
Okay, calling the case then of People versus Corey Lee Briggs, file 21-6651-FH. Would counsel identify for the record, please?
Sherman presides, appearing on behalf of the people.
Morning, Your Honor. Gerald White representing Mr. Briggs.
Mr. Briggs, would you raise your right hand to be sworn, sir?
Yes, sir.
Do you solemnly swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Could you tell us your name?
Corey Briggs.
Thank you, Mr. Briggs. You may be seated if you'd like. Mr. White, today is the date and time scheduled for a pretrial conference in this matter. How did your client want to proceed, by way of a plea or by way of a pretrial conference?
By way of a pretrial conference, Your Honor, I would indicate for the court that I'm in possession of a probable cause conference summary. It is our intent at this time to take advantage of that. However, one of the conditions was that the defendant, Mr. Briggs, was to obtain a CMH or mental health evaluation and follow recommendations. He is scheduled for his assessment at mental health on July 1. So we were hoping to wait till after that time to try to put a resolution to this case.
Judge, I would point out that
Yes, ma'am.
today was the date originally scheduled for an arraignment. Defendant filed a waiver of arraignment and the court then changed the arraignment to a pretrial. So we weren't prepared to go forward with a pretrial today anyway. And so we would ask for this court to set it out for another pretrial conference.
Okay, thank you, ma'am. Very well, then we'll schedule it for a pretrial conference on Monday, July 12th at 9:20 a.m. Work for you, Mr. White?
That would be perfect, Your Honor, I think.
Actually, I think I gave you the wrong day. We'll say Monday, July 19 at 9 a.m. and 9:20 a.m., pardon me. And the case will be adjourned to that date and time, Monday, July 19 at 9:20 a.m. Thank you for being here, sir.
Thank you, Your Honor.
Thank you, Mr. Mercedes. The case will be adjourned to the date and time indicated. Bond will be continued.
And the only other one that we currently have Todd on and we have Jill Tanner present.
Let's see, Todd Dietrich.
He shows that he's logged on. I don't know if he's there.
Todd, can you hear us?
Yes, I can hear you.
Superintendent Jill Tanner, we do have her available.
Steve, I'm sorry. There's a couple of Jerry's cases who didn't show up for the PSIs.
Oh,
We'll do those.
Are you going to do those before you get to Todd's?
Addison Russell and Jessica Carlton.
Okay.
And Jill and Brandon Brown as well.
How did you want to proceed, Mr. Grant?
Judge, for Mr. White, there's Addison Russell and Jessica Carlton have case reports from the probation department that neither one of them showed up for their PSRs.
Okay, thank you. Calling the case of People versus Addison Lynn Russell, file 20-6435-FH. Would counsel identify for the record, please?
Good morning, Your Honor. Mark Webb on behalf of the people.
Morning, Your Honor. Once again, Gerald White representing Miss Addison. Excuse
The
me.
record should reflect today was the date and time scheduled for a sentencing of Ms. Addison, of Ms. Russell, pardon me, Ms. Addison Lynn Russell. And according to the pre-sentence investigation report update from the probation department, quote, the PSI interview has not been conducted, unquote. Therefore, it is respectfully recommended sentencing be adjourned for 2 weeks in order to complete the PSI for the court. We'll schedule the sentencing then to occur on Monday, July 19, 2021 at 9:20 a.m. The bond status will be continued. The case will be adjourned to that date and time. And calling the case of People versus Jessica Lee Carlton, file 21-6563-FH. Would counsel identify for the record, please?
Good morning, Your Honor. Mark Webb on behalf of the people.
Morning, Your Honor. Gerald White representing Miss Carlton.
Ms. Carlton appeared in court back on April 19, 2021, at which time she pled guilty to the felony crime of attempted conspiracy to furnish contraband to prisoners. She was scheduled to appear here today to be sentenced at 9:20 a.m. It's more than an hour past that time. It's 10:26 a.m. by the court's clock. Ms. Carlton has failed to appear. In addition, according to the probation department, they have provided to the court and counsel a copy of their case report reading in pertinent part. Quote, at the time of this report, the defendant has failed to contact the department or this agent to schedule her PSI interview. Therefore, it is respectfully recommended that a warrant be issued for the defendant's arrest and she be held in jail until a PSI interview can be completed for the court, close quote. Very well, then the court will revoke and forfeit the defendant's bond and issue a bench warrant for her arrest. Bond on the bench warrant will be in the amount of $3,000 cash only, to be posted only in the defendant's own name, and she will be brought before the court to show cause why she should not be held in criminal contempt of court for allegedly failing to appear here today. The record should reflect it's 9:27 a.m. by the court's clock, and Ms. Carlton still has failed to appear. Calling the case of People versus Daniel Harley Tice, file 21-6648-FH. Would counsel identify for the record, please?
Good morning, Your Honor. Mark Webb on behalf of the people.
Morning, Your Honor. Gerald White representing Mr. Tice.
The clerk has handed to me a waiver of arraignment form, which you had filed with the court earlier today, Mr. White, and which I signed a little earlier. So thank you. That matter has been addressed, and pleas of not guilty will be entered on behalf of defendant Tice. and the matter will proceed to a pretrial conference or other disposition. And calling the case of People versus Jedediah Lauren Brown, file 21-6541-FH. Would counsel identify for the record, please?
Michelle Rosales, speaking on behalf of the people.
Your Honor, Gerald White representing Mr. Brown.
Is Mr. Brown present?
Incarcerated, Your Honor.
I'm sorry, Mr. White, what was that, sir?
He is incarcerated. Mr. Brown is.
And we have the jail and it's showing the bottom of the chair, the video. I'm not exactly.
I
sure
just
what's
called
going
to
on.
see if they can,
And I don't know, is that Clare County? Okay, I just wanted, I didn't know whether that's Clare or County.
Thank you, Lori.
there's not a second login, is there, from the jail? Okay, Joe, we got it, thank you.
I think we're going somewhere now.
Calling the case of People versus Jedediah Lauren Brown, file 21-6541-FH. Would counsel identify for the record, please?
Michelle Rosales, speaking on behalf of the people.
Morning, Your Honor, Gerald White representing Mr. Brown.
And are you Jedediah Lauren Brown?
Yes, I am.
Mr. Brown, you appear here today for a status conference. How does your client want to proceed with regard to the status conference?
Well, Your Honor,
Mr. White?
Thank you, Your Honor. I have in my possession a pretrial summary that I've gone over with Mr. Brown in the past, and we're not in a position to accept the offer that's been made by the prosecutor's office at this time.
All right, then the case will proceed to trial on the 10-year felony crime of carrying of a concealed weapon plus habitual offender third offense notice. Thank you for being here, Mr. Brown.
Yeah.
And we'll see you at trial. Thank you for being here, sir. Make sure you stay in touch with your lawyer.
I tried to, but he never gets over it.
Well, he's probably a very, very busy man. So the burden is going to be on you to get a hold of him. And frankly, sir, if you screw it up and you don't stay in touch with him, you're the one who's going to pay the price for that, not your lawyer. So you should be very highly motivated to do what you need to stay in touch with them. Thank you for being here, sir. Is that the last of your cases, Mr. White?
It is, Your Honor. Thank you.
Thank you.
Joe Tanner connecting right now. That is the only one of Mr. Dietrich's defendants that is calling in. I don't know if he has any knowledge.
Thank you.
His most knowledge.
Calling the case of People versus Jill Marie Tanner, file 14-4968-FH. Would counsel identify for the record, please?
Members, I speaking on behalf of the people.
Thank you, Your Honor. Todd Dietrich, bring on behalf of Ms. Tanner, also known as
And
Parson.
Miss, are you, thank you. Thank you, Mr. Dietrich. And Ms. Tanner, are you Jill Marie Tanner?
You have to unmute your microphone, ma'am.
Yes.
Previously, Ms. Tanner, back 6.5 years ago, back on February 17 of 2015, you appeared in court, and at that time, you pled guilty to furnishing contraband to a prisoner. You appear here today to be sentenced. The maximum penalty the court could impose would be 5 years in prison. The minimum sentence is discretionary with the court, and the Clare County Circuit Court Probation Department and the Michigan Department of Corrections have prepared both a pre-sentence investigation report as well as a sentencing information report. And in those two reports, at least thus far, they calculate your applicable sentencing guideline range to be 0 to 11 months. Although pursuant to Mrs. Lockridge, those guidelines now are advisory instead of mandatory. Do you understand those things, Ms. Tanner?
I do.
Mr. Dietrich, have you gone over these reports with your client?
I have, Your Honor.
Is there anything in either report of a factual nature that you want to add to or explain or contradict?
No, Your Honor.
Do you have any challenges to the scoring of the offense variables or prior record variables or the calculation as to the applicable sentence range as being 0 to 11 months?
No, Your Honor.
And on behalf of the people, I pose the same series of questions to you.
Your Honor, we have had the opportunity to review the pre-sentence investigation report. We do find it to be factually accurate. I've also reviewed the prior record variable scoring and the offense variable scoring and find those to be accurate as well, though I would state that there was a Briggs-Killebrew agreement to a 4-month cap as to initial incarceration. However, in light of the defendant's failure to appear since 2015, I do believe that the court is not bound to follow that Briggs-Killebrew and that the defendant would be unable to withdraw her plea because of her bench warrant status. Thank you.
Thank you, ma'am. And Ms. Tanner, is there anything you want to say on your own behalf, ma'am, before the court proceeds to sentencing you?
No.
And on behalf of your client, Mr. Dietrich?
Yes, Your Honor. Thank you. Your Honor, I imagine there's at least two ways of looking at the situation with Ms. Tanner. Number one is, as Ms. Ambrositis pointed out, and the court noted the years that have passed since Ms. Tanner had taken the plea and then failed to show up for sentencing. And the court could reflect on that and say, well, you know, shame on you. I'm going to punish you severely now. And I'm going to give you a worse situation than you would have had you just shown up. But I would ask the court to consider a second perspective in that looking at her criminal history, specifically between the years of 2013 and 2016, appear to be some pretty tumultuous years for Ms. Tanner. And I think she was kind of out of control for herself. I think she was having a difficult time trying to rein the situation in. There was obviously some addiction issues that were going on at that time. But since it appears since about 2016, she has significantly changed her life on her own. She's not, no longer has the addiction issue. She's gotten married, has stable employment, and most importantly of all, she had been arrested after this event, and I guess the state could have brought her up here. But after all these years, she actually contacted me. She called me and said, "I don't know if you remember me, but a long time ago, you were representing me in a case, and I didn't do the right thing, and I didn't turn myself in, and I would like your help now to do the right thing, to get this back on track, so I can just move on with my life, because I've changed my life significantly, and I know I gotta resolve this issue." And so she did that all on her own. I didn't reach out to her in numerous years. So I did that. I helped her get this case back on track. She's standing up, taking responsibility. The recommendation is 3 days with 3 days served, and I assume that that's based on the interview that the author of the pre-sentence report had with Ms. Tanner, looking into her history, seeing the significant changes and positive changes that she's made in her life. And so I know from a legal perspective and just a judicial system perspective, it may seem a little odd to ask for no more incarceration after she had basically not shown up for numerous years, but she has made vast positive changes in her life that I would ask the court take into consideration. And the fact that, this was still looming over her head. She reached out to the counsel she had before, asked that it be, it's time for me to address this issue, and I need to go forward. And I would ask the court to give no further incarceration. Thank you.
Yes, sir. And on behalf of the people,
Well, I guess I suppose we could send the message that, if you avoid your legal issues long enough, and come in and say, well, look, I didn't get in too much trouble while I was avoiding these things. I shouldn't have any consequences for my actions. I will leave it to the court to determine what sentence you want to impose. Thank you.
thank you, ma'am. Very well, Ms. Tanner, in order to punish you for what you've done and to deter you and others from committing crimes in the future, but also to give you the chance to rehabilitate yourself, you must pay $68 in state costs and a crime victims assessment of $130, court costs of $500, and a fine of $500. And do you have an estimate as to attorney fees, Mr. Dietrich?
So, Your Honor, she actually retained me at this point in time, so I don't believe there's any attorney fees at this point in time.
Okay, thank you, sir. Of that approximately $1,200, how much do you have available today to apply towards your court-ordered monies, Ms. Tanner?
I did post a bond, $2,000 when I spoke with you about getting final. It was a couple weeks ago. I don't remember the exact date, but I have a $2,000 I can apply.
So you posted $2,000 cash only in your own name?
Yes.
Very well then, ma'am, in order to punish you for what you have done, you must serve 4 months in the Clare County Jail with credit for 3 days served. If you pay the entire amount owed in full, I will suspend the balance of the jail time.
It was never forfeited, it was just canceled. I don't see that it's forfeited.
In any event, ma'am, that will be the sentence of the court. Now, I'm disquieted by some of the same things the prosecutor is, which is basically if you skip out for 6.5 years and you're a complete, I was about to say complete scofflaw, but maybe not a complete scofflaw, because based on your prior conduct up until 2014, if you were out there committing crimes, we would have caught you because you weren't very darn good at it.
Yeah.
You've done a few positive things in your life since then, as far as staying out of jail. I don't know if I'm sending the correct message or not, to be honest with you, because I have a feeling if I were to stop 10 average men and women on the street and ask their opinion of what I'm doing, most of them would say, why aren't you throwing this gal in prison? Or at the very least, giving her 11 months in the county jail. Because I want you to fully understand the prosecutor is 100 about what the state of the law is. If you skip out after entering a plea according to a plea agreement, the people and the court are no longer bound by that plea agreement. This will be the sentence of the court, though. You're sentenced to serve 4 months in the Clare County Jail with credit for 3 days served. And any bond posted in your own name will be canceled. Any bond posted in your own name will be applied towards court-ordered monies. Once all of the fines and costs and fees and other court-ordered monies are paid in full, you will be released from the county jail. Thank you for being here, ma'am. It's my duty to inform you that you are entitled to appellate review of your conviction and sentence. And if you are financially unable to hire a lawyer, then the court will appoint a lawyer for you and will furnish that lawyer with the records and the transcripts that are necessary to perfect an appeal. But a request for the appointment of an attorney must be made within 42 days of today's date in writing and sent directly to the court. Thank you for being here, Ms. Tanner.
Your Honor.
We'll be in recess on that case. Does anyone else check?
We have Dietrich client. Mr. Dietrich, who is appearing in your office?
I believe that's Mr. Askew.
That's who we have available.
Thank you. Calling the case of People versus Braden Scott Askew, file 21-6603-FH. Would counsel identify for the record, please?
Sean Brzezowski, appearing on behalf of People.
Thank you, Your Honor. Todd Dietrich appearing on behalf of Mr. Askew.
And are you Braden Scott Askew?
You need to unmute your microphone, sir.
Yes, sir.
Previously, Mr. Askew, back on April 19 of 2021, you appeared in court in this file, and at that time, you pled guilty to the 4-year felony crime commonly known as assault with a dangerous weapon. You appear here today to be sentenced. The maximum penalty the court could impose is 4 years in prison. The minimum sentence is discretionary with the court and the Clare County Circuit Court Probation Department and the Michigan Department of Corrections have prepared both a pre-sentence investigation report as well as a sentencing information report. And in those two reports, at least thus far, the departments calculate your applicable sentencing guideline range to be 0 to 3 months. Although pursuant to People versus Lockridge, those guidelines now are advisory instead of mandatory. Mr. Dietrich, have you gone over those reports with your client?
Your Honor.
Is there anything in either report of a factual nature that you want to add to or explain or contradict?
No, Your Honor.
Do you have any challenges to the scoring of the prior record variables or the offense variables, or the calculation as to the applicable sentencing guideline range as being 0 to 3 months?
No, Your Honor.
And Ms. Ambrositis, on behalf of the people, I pose that same series of questions to you.
Your Honor, we have reviewed the pre-sentence investigation report. We do find it factually accurate. We've also reviewed the prior record variable scoring and the offense variable scoring and find that to be accurate as well.
Mr. Askew, is there anything, sir, you want to say on your own behalf before the court passes sentence?
Yes, sir. I just want to let the courthouse know that I did make a mistake, and I am realizing now I have a daughter and I have a good job, and I don't want one bump in the road to mess up what I have going for me right now. That's it, sir.
Thank you, sir. And on behalf of your client, Mr. Dietrich?
Yes, Your Honor. I had spent some significant time talking with Mr. Askew. I guess I would point out he's a very well-spoken young man, very clean cut. I think in the situation, he kind of got humiliated in front of his significant other, and he's embarrassed. And I think he handled it incorrectly. And he and I spoke in detail about that and better ways to deal with those situations. And I think that the delay of sentence is a great opportunity for him to learn this lesson. And yet, know that going through this process and being involved in the judicial system is nothing that he wants for his life or his family. And I think will be a key in rehabilitation for him in terms of at least a deterrence for any future behavior that could put him in this situation again. So I would ask the court to follow the agreement, and I'm fairly certain he's going to do quite well on probation, Your Honor. Thank you.
Thank you. Are there any victims present who wish to speak to the issue of sentencing? The record should indicate no response, and on behalf of the people, Ms. Ambrositis?
And we're going to ask that you follow the recommendations in the agreement in this matter. The defendant in this case is truly deserving of the delay of sentence and the opportunity to walk away without a felony conviction.
Thank you, ma'am. Very well then, Mr. Askew, in order to punish you for what you have done and to deter you and others from committing crimes in the future, but also to give you the chance to rehabilitate yourself, it's the sentence of the court. You'll be placed on what is commonly known as delayed sentence probation for a period of up to 1 year. In addition to all of the statutory terms of probation, you also must abide by all the written terms of your probation order. And all of those terms together include but are not limited to: you must not use or possess any alcohol or controlled substances or drug paraphernalia. You must submit to alcohol and drug testing on demand, and you must successfully complete any substance abuse treatment program to which you are referred by the probation agent, and give up any confidentiality right you have in any such program so that the court may monitor your progress. You must not have any contact with anyone whom you know to have a felony record unless you first get written permission to do so from the probation agent. You must not engage in any assaultive, abusive, threatening, or intimidating behavior, or possess any weapons or copies of weapons. You must submit to a search of your person and property without the need of a search warrant. Further, the probation agent does have the legal right to arrest you if he has reason to believe you are conducting yourself in a manner inconsistent with the public good, or that you have violated your probation. You must seek and maintain full-time employment and or be enrolled in a full-time education program. You must not be within 500 feet of Thomas Swigart or have any contact with him whatsoever. You must comply with DNA testing and pay a $60 fee for that purpose. You must pay $68 in state costs and a crime victims assessment of $130, court costs of $500, and a fine of $500. And do you have an estimate as to court-appointed attorney fees, Mr. Dietrich?
I do, Your Honor, $490.
Thank you, sir. So how much of that approximately $1,760 do you have available today to apply towards your court-ordered monies, Mr. Askew?
I have about $250, sir.
You must pay $250 today, and then you must pay an additional $300 per month to be due and payable by the first day, by 12 noon on the first day of each month, starting on July 1 until paid in full. But it all must be paid by the time you get off of probation. In addition, you must pay a supervision fee of $30 per month. And that's if you are not on electronic monitoring. If you are placed on electronic monitoring, you must pay $60 per month. Now, sir, this is going to be difficult for you to pay all of this money by the time you get off of probation, but it's a condition of your probation, so you're going to have to buckle down and do it. I'm not going to give you any jail time today, and if you do everything you're supposed to do while you're on probation, delayed sentence probation, then at the end of that time period, you won't have a criminal record as a result of this incident, at least. But this was incredibly stupid. It was just incredibly stupid. And I believe your lawyer, he has a lot of insight into people, and he has a lot of human experience too. I think you probably were humiliated. And in that setting, you reached for a weapon. You didn't flip the weapon open as far as anybody knows. and you say, no, you didn't open up the knife, but obviously you were holding the weapon, seeking to intimidate these two men. If things had gone south from there, you could have wound up in prison, and you would not have a pleasant time of it in prison. Nobody does, but you in particular would not. This is not fun and games here, and I think you are beginning to realize that. If you do everything you're supposed to do over the next year, you're going to come out of this situation without a felony conviction, and you're going to be a better, stronger person because of it. But there's no guarantee everything will go according to plan. You control almost all of that, but even you don't control all of it. Good luck to you, sir. Because I've not imposed a final sentence, there's no need to advise you of any appellate rights because they don't get attached. Agent Brubaker, do you have any additional instructions you want to give to Mr. Askew?
Yes, thank you. Mr. Askew, you need to contact Agent McConnell today. And are you ready for his phone number?
Yes, ma'am.
989-329-9820. Okay?
Yes, ma'am.
All right, thank you, Your Honor. I'm all set.
Thank you, ma'am. Good luck to you, sir. Calling the cases of People versus Corey Scott Sly, file 19-6205-FH and file 20-6444-FH. Would counsel identify for the record, please?
Good morning, Your Honor. Mark Webb on behalf of the people.
Thank you, Your Honor. Todd Dietrich, bring on behalf of Mr. Sly.
And sir, are you Corey Scott Sly?
Unmute your microphone, sir.
Gotta move the cursor around. There you go.
Mr. Sly, in file 19-6205-FH, you currently are on probation to this court in that file for the 10-year felony crime commonly known as possession of methamphetamine, and for the 1-year misdemeanor crime commonly known as child abuse in the 4th degree. You appear here today for sentencing as to, in that file, as to those two underlying convictions. The applicable sentencing guideline range for the felony conviction is 0 to 17 months, although pursuant to People versus Lockridge, those guidelines now are advisory instead of mandatory. And the Clare County Circuit Court Probation Department and the Michigan Department of Corrections have prepared a probation violation report update in that file as well. In file 20-6444-FH, previously served back on April 19 of 2021, you appeared in court, and in that file, you pled guilty to the 10-year felony crime of aggravated stalking, plus being a habitual offender, 3rd offense notice. Now, aggravated stalking is a felony, and normally it would carry a maximum penalty of 5 years in prison. However, when it is coupled with a conviction for being a habitual offender, third offense notice, the net effect of those things is that the court in its discretion can double the maximum penalty from 5 years in prison to 10 years in prison. It would be discretionary with the court whether or not to double the maximum end of the sentence in that 2020 file. And regardless of whether the court did so, the minimum end of the sentence still would be discretionary with the court. Do you understand all of these things, sir?
Yes, Your Honor.
Now, the Clare County Circuit Court Probation Department and the Michigan Department of Corrections have prepared a pre-sentence investigation report and a sentencing information report in the 2025. And thus far, the departments calculate your applicable sentencing guideline range to be 12 to 36 months. Although pursuant to People versus Lockridge, those guidelines now are advisory instead of mandatory. Mr. Dietrich, have you gone over all of these reports in both of these files with your client?
I have, Your Honor.
Is there anything of a factual nature in either report that you want to add to or explain or contradict?
No, Your Honor.
Do you have any challenges to the scoring of the prior record variables or the offense variables or the calculation as to the applicable sentencing guideline range in the 2020 file as being 12 to 36 months?
I'm sorry, which file, Your Honor, is 12 to 36?
In the 2020 file, the guidelines were calculated to be 12 to 36 months. Do you have
Yes,
any challenges to those guidelines?
No, Your Honor, I apologize. I was looking at the 2019 document as you were saying that. That's why I was confused, but no.
Thank you, sir. And on behalf of the people, I pose the same series of questions to you, Mr. Webb.
Thank you, Your Honor. I've reviewed the reports, have no additions or corrections to make to them. And I believe the guidelines are correct.
Thank you. Mr. Sly, is there anything, sir, you want to say on your own behalf before the court passes sentence?
Yes, Your Honor. I'd just like to say that I apologize to the court. And I apologize to you as well. And most of all, I just want to apologize to my family and my children and my wife that they're have the more taken out of this than anybody else, and they didn't deserve any of this. And that's it.
Thank you, sir. And on behalf of your client, Mr. Dietrich?
Yes, Your Honor. I went over the pre-sentence report with Mr. Sly, and I got to the portion. There was a very long, detailed letter from his wife to the court that was included in the report, and I thought it was very sincere and insightful, both for the court, myself, and for Mr. Sly. To be honest with you, I think that Mr. Sly was able to see himself through his wife's eyes when I read the letter to him. And, you know, he definitely teared up, as I think he is right now. I think he's come to a very strong realization that his actions have affected adversely the people that he cares about the most in life. And I think it's something that he wants to remedy. I know there's a recommendation for no contact with his wife at this point in time. It appears that she wants contact at some point in time. And so I ask that at least be addressable in the future at some point. I would ask, with all that said, that the court follow the agreement and give Mr. Sly the appropriate jail credit that he already has on the 2 cases, in hopes that he can pull this off. It does appear that some substance abuse counseling, or at least addressing that issue, would be appropriate through the probation period. And I think Mr. Sly is aware of that. I think he acknowledges that. I think he wants it because he wants this problem solved. He wants a healthy life. He wants a healthy relationship with his family. So I would ask the court to follow the agreements in these files. Thank you.
Thank you, sir. Are there any victims present who wish to speak to the issue of sentencing?
Not that I'm aware of, Your Honor. I've checked our notes. I didn't see anything in the file that she had contacted us to want to be able to address the court today. But I would ask you to, and I'm sure you probably already have taken a good close look at that letter that she sent.
Thank you, sir. Thank you, Mr. Webb. And on behalf of the people,
I'd ask you to follow the plea agreement recommendations from the probation department.
very well then, in the 2019 file 19-6205-FH, for the underlying conviction for child abuse in the 4th degree, you are sentenced, sir, to serve in order to punish you for what you've done and to deter you and others from committing crimes in the future, but also to give you the chance to rehabilitate yourself in both of these 2 files. It's the sentence of the court as follows. In the 2019 file, for the probation violations for the underlying misdemeanor conviction of child abuse in the 4th degree, you are sentenced to serve 1 year in the Clare County Jail with credit for 328 days served. In that same file, for the conviction of possession of methamphetamine, you are sentenced to serve 1 year in the Clare County Jail with credit for 328 days served. These 2 sentences will run concurrently to one another. They will run at the same time, and you must pay all the court-ordered money you previously ordered to pay in that file as well. Turning to file 20-6444-FH for the underlying conviction for aggravated stalking plus being a habitual offender, 3rd offense notice. It's the sentence of the court. You'll be placed on probation for a period of 5 years. In addition to all of the statutory terms of probation, you also must abide by all the written terms of your probation order as well, which include, but limited to, you must not use or possess any controlled substance drug paraphernalia, or alcohol, and you must submit to drug and alcohol testing on demand, and you must successfully complete any substance abuse program to which you are referred by the probation agent, and give up any confidentiality right you have in any such program. You also must successfully complete any mental health treatment program or violence or pattern intervention treatment program, and give up any confidentiality right you have in any such program as well, so that the court may monitor your progress. You must not engage in any assaultive, abusive, threatening, or intimidating behavior, or possess any weapons or copies of weapons. You must submit to a search of your personal property without the need of a search warrant. Further, the probation agent does have the legal right to arrest you if he has reason to believe you have violated your probation, or even merely reason to believe you are conducting yourself in a manner inconsistent with the public good. You must not have any contact with anyone whom you know to have a felony record. You must not have any contact with Helena Sly or be within 500 feet of her residence, school, or place of employment. You must abide by a curfew and be in an approved residence every day from 10 p.m. until 6 a.m. unless you first get written permission otherwise from the probation agent. You must serve 1 year in the Clare County Jail with credit for 291 days served. You must pay $68 in state costs and a crime victims assessment of $130, court costs of $500, and a fine of $500, and court-appointed attorney fees. Do you have an estimate, Mr. Dietrich?
Yes, Your Honor. In the probation violation file was $340, and in the 2020 file was $520.
Very well, $520 in the 2020 file and $340 added to the court-ordered money previously ordered to be paid in the 2019 probation violation file. Further, you must, in the 2020 file, pay $30 per month for any time period in supervision fees while you're on probation, unless you are being electronically monitored, in which case it will be $60 per month. Your 7411 status will be revoked in the 2019 file. And as a consequence, your driver's license will be suspended or revoked according to state law in that file as well. So I apologize for being a little bit disjointed going back and forth between the two cases. With regard to the 2020 file, once again, you must serve 1 year in the Clare County Jail with credit for 291 days served, but that sentence will be concurrent to, it will run at the same time as the 2019 file, although the amount of jail credit you get might be different in the two files, and it will be different in the two files. Mr. Sly, I have no idea whatsoever if you can repair things with Helena or not. I frankly doubt it. You've behaved like a complete idiot, and more than an idiot. I mean, you've behaved in a very violent, controlling way. And quite frankly, women don't like to be treated like possessions. Nobody does. And whether you can someday, somehow make that right, I don't know. If it was up to me, if I was in her shoes, no, you couldn't. I suppose there's some small glimmer of hope that maybe someday when you're off probation and someday when you're permitted to have contact with her, maybe you can repair things. I don't know. But I can tell you this, unless and until you get permission from your probation agent to have contact with her, you better not be having contact, because it's a term of probation not to have contact with her, and it will be enforced. It's my duty to inform you that you are entitled to appellate review of your convictions and sentences. And if you are financially unable to hire a lawyer, then the court will appoint a lawyer for you and will furnish that lawyer with the records and the transcripts that are necessary to perfect an appeal. But a request for the appointment of an attorney must be made within 42 days of today's date in writing and sent directly to the court. Bond is canceled, any bond posted in the defendant's own name will be applied towards court-ordered monies. And Baker, do you have any additional instructions to give to Mr. Sly?
Yes, thank you, Your Honor. Mr. Sly, your probation agent is Agent Rebecca Medley. When you leave the jail, please ask the jail staff for her phone number so that you can contact her immediately. You have to contact her within the next business day of your release.
Yes, ma'am.
Thank you. I'm all set.
Thank you. Good luck to you, sir. We'll be in recess in that matter.
Thank you, Your Honor.
You're welcome, sir.
Next, Mr. Wallace and Ms. Burzak Mulholland have not appeared.
Okay. Calling the case of People versus Thomas Walasanowicz, Thomas Allen Walasanowicz, file 21-6559-FH. Would counsel identify for the record, please?
Michelle Mercedes, appearing on behalf of the people.
Thank you, Your Honor. Todd Dietrich appearing on behalf of Mr. Wilsonovich.
Mr. Walasanowicz previously had entered a plea in this matter. He was scheduled to be sentenced here today at 9:39 a.m. It's now going on 2 hours past that time. It's 11:22 a.m. by the court's clock. Mr. Walasanowicz has failed to appear. In addition, the people had filed a motion to revoke his bond, and that was scheduled to be heard today as well. And Mr. Walasanowicz has failed to appear for that bond revocation matter, that motion. The court will cancel, revoke, and forfeit the defendant's bond in this case and issue a bench warrant for his arrest for criminal contempt of court for allegedly failing to appear here today. Bond on the bench warrant is set in the amount of $3,500 cash only to be posted only in Mr. Walasanowicz's own name. The record should reflect it's 11:23 a.m. By the court's clock, Mr. Walasanowicz still has failed to appear. Mr. Dietrich, I think I did jump the gun a little bit. Did you know of any reason why Mr. Walasanowicz has failed to appear here today, sir?
No, Your Honor. I had a very lengthy conversation with Mr. Wilsonovich yesterday on the telephone. And we were discussing that I felt there were some details that still needed to be worked out on his case, which I did try to continue with Ms. Ambrositis this morning. I am a little curious if he took that to mean that he didn't have to show up today, but I don't know. I'm kind of surprised he's not on, and I just tried to call him and there was no answer, Your Honor.
Thank you, sir. I'm sure he didn't interpret what you said. He's a full-grown adult. He's no naif when it comes to the criminal justice system, that he was fully aware he was to be here today, and he has failed to appear at 11:04 a.m. by court's clock, more than 2 hours past the scheduled time. So the action the court took and placed on the record earlier will stand. Thank you for being here, Mr. Dietrich. Thank you, Ms. Ambrositis.
Thank you, Judge. Could you tell me again what the bond and the bench warrant is, please?
$3,500 cash only, to be posted only in Mr. Walasanowicz's own name.
Thank you.
Thank you, ma'am.
Ms. Burzak is scheduled, Mulholland is scheduled for sentencing. She was not here.
Thank you, ma'am. Calling the case of People versus Lisa Mulholland, file 20-6498-FH.
I apologize, Judge. She is lodged. She's here.
Okay. And also the case of People versus Lisa Burzak, file 20-6504-FH. Those two individuals are one and the same person, apparently, and appearing on behalf of the people.
Michelle Ambrositis appearing on behalf of the people.
And appearing on behalf of the defendant.
Thank you, Your Honor. Todd Dietrich appearing on behalf of Ms. Burzak, who previously known as Ms. Mulholland.
Ms. Mulholland or Ms. Burzak, would you please raise your right hand to be sworn, Miss?
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Could you tell us your name?
Lisa Marie Mulholland, Burzak.
Today is the date and time scheduled for a status conference in these two felony matters. How did your client want to proceed, Mr. Dietrich?
Your Honor, there is a new pending court case in district court. I would ask that the court put this out approximately 4 to 6 weeks for another status conference to see if we can get these matters resolved. If the court's okay, the prosecutor's okay with that.
Is there any objection to that, Ms. Ambrositis?
No, thank you.
Very well, then we'll schedule the cases for these two cases today. We'll schedule for a status conference to occur on Monday, August 2nd at 9:20 a.m. The bond status in each case will be continued. The cases are adjourned to the date and time indicated. Monday, August 2nd. Thank you. Thank you for being here, Ms. Burzak, Ms. Holland, Ms. Mulholland, pardon me, AKA Ms. Burzak. Make sure you get in touch with your lawyer, Ms.
Your Honor, I do have a scheduled status conference or a pretrial in probate court at 11:30. I don't know how the court would like me to handle that. I think we have one more case with Mr. Shook for sentencing.
Okay, calling the case of People versus William Sheldon Shook, file 20-6518-FH. Would counsel identify for the record, please?
Joan Brzezis, appearing on behalf of People.
Thank you, Your Honor. Todd Diedrich appearing on behalf of Mr. Shook.
And are you William Sheldon Shook?
He's on his way.
Is what?
He's on his way.
Oh, okay. Mr. Dietrich, apparently we're waiting a few minutes for Mr. Shook. Would you rather go attend to the probate court matter first? And come
The court,
back afterwards?
if the court's okay with that, that'd probably be fine. I can see there's other attorneys waiting, so that's fine with me, Judge.
Okay, thank you, sir. We'll pass on your matter then.
Thank you.
Sure.
Could you please identify yourself for the court?
I'm Jennifer Kuiper Weesey, Your Honor. On behalf of Joshua Murdoch.
We do have Mr. Murdoch here. Do you want to take that case, or is there another case that you prefer to take, Judge?
I guess, what is the Murdoch case?
It looks like a pretrial hearing on the last page.
Okay, thank you. Sorry, Dave. Calling the case of People versus Joshua John Murdoch, file 21-6593-FH. Would counsel identify for the record, please?
Joan Brzezis, appearing on behalf of People.
Thank you, Your Honor. Jennifer Kuiper Weesey on behalf of my client Joshua Murdoch.
Today is the date and time scheduled for a pretrial conference in this case. Did you want to proceed by pretrial conference or by way of a plea, Ms. Keeper Weiss?
Thank you, Your Honor. We are prepared to enter a plea of no contest today.
Your Honor, if I may,
Yes, ma'am. Go ahead, Ms. Ambrositis.
on the printer in the law library, there should be the advice of rights from the defendant. I printed that there, and I do believe my staff brought up the signed offer of proof.
They did deliver an offer of proof. Thank you, ma'am. And would this be a plea to what count or counts?
Count 2 and an added count 5, Your Honor, of accosting a child for immoral purposes.
So count 2 and count 5.
Was it amended felony information filed? I thought I did that.
We don't have, I don't believe we have an amended with the file. We have the offer of proof, but no amended.
I can do an amended really quick.
Okay, what we'll do is we'll pass that matter for a moment. And do you need to confer with your staff, Ms. Ambrositis?
I can type it up from right from my computer.
Okay, thank you, ma'am.
Mr. Gilbert's client is failure to appear, so I don't know if you want to take his.
Well, I would accept except I think Michelle is occupied.
Go ahead and take care of what you need to here.
Your guys do a final delete sentence, right?
I guess, yes.
Guy being your gal.
No, that's the one we're gonna come back to, Todd. I'll get back to you.
The amended felony information should be printing to the law library printer.
Thank you.
Thank you, Ms. Ambrositis.
We see, I'll email that to you here momentarily.
Thank you, ma'am.
Thank you.
Calling the case of People versus Joshua John Murdoch, file 21-6593-FH. Would counsel identify for the record, please?
Joan Besides appearing on behalf of people.
Thank you. Jennifer Capolici on behalf of Mr. Murdoch.
Mr. Murdoch, would you please raise your right hand to be sworn, sir?
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Could you tell us your name?
Joshua John Murdoch.
Mr. Murdoch, do you understand that according to count 2 of the information and count 3 of the amended information, we'll just go from the amended information, according to count 2 and count 5 of the amended information, that you are charged with the 4-year felony crimes commonly known as accosting a child for immoral purposes?
Yes, Your Honor.
Each one of those crimes is a felony. Each one of those crimes carries a maximum penalty of 4 years in prison and/or a fine of up to $4,000. And each one of those crimes is a tier 2 offense under the Michigan Sex Offender registration, and that would be a tier 3 offense under that act if you have a prior conviction for a violation of a tier 2 offense. Do you understand those things?
Yes, Your Honor.
Other than that, the minimum end of each sentence would be discretionary with the court. You understand those things?
Yes, Your Honor.
With regard to count 2, accosting a child for immoral purposes, and also with regard to count 5, accosting a child for immoral purposes, you may make any of the following 4 pleas. First, you may plead guilty if you are guilty, but don't plead guilty unless you are guilty. Second, you may plead not guilty. Third, you may stand mute and say nothing, in which event the court would enter a plea of not guilty for you. And fourth and finally, you may plead no contest, which means that you do not contest the prosecutor's proofs, and it amounts to a plea of guilty. Do you understand the 4 possible pleas you may make to count 2 and count 5?
Yes, Your Honor.
In answering to count 2, accosting a child for immoral purposes, what is your plea?
I plead no contest, Your Honor.
In answering to count 5, accosting a child for immoral purposes, what is your plea also?
I plead no contest, Your Honor.
Now, sir, do you understand that no one can make any promises for me about what your sentence will be or what your sentences will be?
Yes, Your Honor.
The court also informs you if your pleas of no contest are accepted, then that means you won't have a trial of any kind, and you therefore would be giving up each and every one of the following rights: the right to have a trial by a jury, the right to have a trial by a judge sitting without a jury if you prefer, the right to be presumed innocent until proven guilty, the right to require that the prosecutor prove you guilty beyond a reasonable doubt, the right to have all of the witnesses against you to appear at the trial, and for you and your lawyer to have the chance to question and cross-examine each of those witnesses, the right to have this court order any witnesses that you might want for your defense to be required to appear at the trial, the right to remain silent during the trial and to not have your silence used against you. But finally, you also do have the right to testify at the trial. And if you choose to do so, then your testimony would be in the same manner as the testimony of any other witness. Do you understand all of these rights?
Yes, Your Honor.
And do you understand that by pleading no contest to count 2 and count 5, that means you will be giving up each and every one of those rights?
Yes, Your Honor.
Now, I'm going to ask your lawyer and the elected prosecuting attorney to tell us what the plea agreement is. And I want you to look at them very carefully. Ms. Ambrositis, what is the plea agreement?
Your Honor, return for the defendant's plea of no contest to count 2 and then the added count 5 in the amended felony information. The people would move to dismiss the remainder upon sentencing and running the appropriate appeals period.
Is
And
there
then
any agreement as to sentencing them?
I do not believe, other than it's within guidelines.
Okay. And on behalf of the defendant, is that your full and complete understanding of the plea agreement as well, ma'am?
Thank you, Your Honor. The plea offer as it relates to the charges is accurate. The prosecutor did agree to sentencing within the guidelines and also not to file a habitual offender notice in this case. But other than that, it is a complete statement of the plea agreement.
With those clarifications, is that your full and complete understanding of the plea agreement then, Miss?
Yes.
Thank you, Ms. Ambrositis, and that's your understanding as well on behalf of the defendant? Is that correct, ma'am?
Yes, Your Honor. Thank you.
All right. Now, Mr. Murdoch, did you hear what the prosecuting attorney and your lawyer said the plea agreement is?
Yes, Your Honor.
Did you understand the plea agreement?
Yes, Your Honor.
And do you agree with that plea agreement?
Yes, Your Honor.
Has anyone asked you anything beyond what is in that plea agreement to get you to plead no contest to count 2 and count 5?
No, Your Honor.
So for example, has anyone promised you that if you plead no contest, that this court then would be lenient or light on you in any way?
No, Your Honor.
Has anyone threatened you or your family to get you to plead no contest?
No, Your Honor.
Is it your own personal choice to plead no contest? And are you doing so freely and voluntarily?
Yes, Your Honor.
Do you have any questions about what the court has told you?
No, Your Honor.
Do you understand everything that the court has told you?
Yes, Your Honor.
And in light of everything that the court has told you, do you still wish to plead no contest to count 2 and count 5?
Yes, Your Honor.
Very well. What is the desire of counsel for the court to review to see if there is a sufficient factual basis for the no contest pleas? Is it the offer of proof?
Yes, Your Honor. Thank you.
Thank you, ma'am. And do you agree, Ms. Ambrositis?
Yes.
Very well. The court has read through the offer of proof and finds that it does establish date being on or about December of 2019, venue being the county of Clare and Clare County, Michigan, identification of the defendant, as well as the elements of 2 separate counts of accosting a child for immoral purposes being count 2 and count 5. Do you agree, Ms. Ambrositis?
Yes.
And do you agree on behalf of the defendant, ma'am?
Yes, Your Honor.
Reason, Ms. Keeper, that you believe a no contest plea is appropriate in this case?
Potential civil liability, Your Honor.
Do you have any objection to a no contest plea, Ms. Ambrositis?
No objection.
Very well, the court does find that the reason given for a no contest plea being for two no contest pleas being minimization of potential civil liability is an appropriate reason, especially since the people have no objection thereto. The court further finds that there is in fact a sufficient factual basis to accept the no contest pleas. Do you agree, Ms. Ambrositis?
Yes.
And do you agree, Ms. Keeper West?
I do, Your Honor.
Has the court complied with the court rule and the taking of the two pleas, Ms. Ambrositis?
Yes.
And do you agree, Ms. Keeper West?
I do, Your Honor, it has.
Very well, in this case, the court has not agreed upon the possible pleas or the possible sentences with the prosecutor or the defendant or defense attorney or anyone else. The court is convinced that the pleas have been made understandingly, knowingly, voluntarily, and once again, understandingly. The pleas of no contest to counts 2 and 5 are accepted and ordered entered on the records of the court. Sentencing will occur at 11 a.m. on Monday, August 2nd, 2021. Is there any issue as to bond, Ms. Ambrositis?
There is no issue as to bond at this point, Your Honor.
Very well, bond will be continued. The case will be adjourned to the date and time indicated, but Mr. Murdoch, Agent Brubaker might have some additional instructions to give to you. Do you have any such instructions, Agent Brubaker?
Yes, thank you, Your Honor. Mr. Murdoch, what is an accurate mailing address for you?
An accurate mailing address, 10926 Roy's Lane, and that's Lake, Michigan, 48632.
And a phone number?
989-817-8352.
You'll be getting a packet in the mail from my office, Mr. Murdoch. Please follow the instructions that are on that packet, okay?
Okay, ma'am.
I'm all set, Your Honor. Thank you.
Thank you, ma'am. Very well, the case will be continued to the date and time indicated. Thank you all for being here.
Thank you, Your Honor.
Thank you, ma'am. And calling the case of People versus Courtney Michelle Metcalf, file 19-6270-FH. Would counsel identify for the record, please?
Schumer Zeiss, appearing on behalf of People.
Good morning, Your Honor. May it please Court Attorney David Gilbert appearing on behalf of Ms. Metcalf. And Ms. Metcalf fails to appear this morning. However, I request the opportunity to address the court before we proceed.
Very well. Ms. Metcalf previously had appeared in court back on July 20th of 2020, at which time she was placed on delayed sentence probation. The probation agent is recommending she be given the benefit of the bargain, but that's difficult to do when she fails to appear. We will schedule sentencing then for 11 a.m. on Tuesday, July 13, 2021. Thank you for being here, Ms. Ambrositis. Thank you for being here, Mr. Gilbert.
Thank you. Thank you, Your Honor.
Thank you, sir. Thank you for being here as well, Mr. Webb. We're getting down to the 1 year mark, so we don't
Rich, do you want me to request that you appear in person? The notice of hearing?
Yes, please. Thank you. Thank you.
The last ones that we have are, Mr. Shook, who is Mr. Dieter, but he is not back in the courtroom. And then the other ones are Scott Moore's that we held off on this morning, but he is obviously not back in the courtroom, so.
Scott?
I think he's on his way, he's ready.
Kim, I didn't see you come in. You're stealthy.
You said Mr. Shook is live.
Hello.
I've really been updated on this. Oh, I'm sorry, Shook is five, he's not ready. Roger Williams, that's the one I was.
Did Karen show up, Township?
She's on her honeymoon.
What are you talking about?
I'm not.
Mr. Williams is more.
I'm still waiting. Josh
Right?
and Carl.
Just take it, just do it.
He's off. He was taken off. We don't have audio yet, with Mr. Williams.
Sir, I left it in pledge. That's, yes.
I show that he has video, but there's no audio. It's trying to connect.
Time, apparently heard that word that I put into the universe because he's going to try to zoom that to prove his contempt.
Scott, I still have not had Gladwin County on at all today, so I don't know.
I'm not responsible for them.
Agreed. Yes, we're ready.
Calling the case of People versus Roger Allen Williams Jr., file 21-6560-FH. Would counsel identify for the record, please?
Michelle Brzezowski, on behalf of People.
If it pleases the court, Scott Moore for the defense.
Mr. Williams, would you please raise your right hand to be sworn, sir?
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Could you tell us your name, sir?
Roger Allen Williams Jr.
Thank you. You may be seated if you'd like, sir. Today was the date and time scheduled for a pretrial conference in this matter. Did you want to proceed by pretrial conference or by waiver of plea, Mr. Moore?
At this time, Your Honor, pretrial conference, if it pleases the court.
Okay. The defendant currently is scheduled with aggravated stalking, which typically would carry a maximum penalty of 5 years in prison. However, because he also was charged with being a habitual offender, second offense notice, if he were to be convicted of both of those matters, the court in its discretion could raise the maximum penalty from 5 years in prison to 7.5 years in prison. You would like the matter scheduled for a jury trial, is that correct, Mr. Moore, on 7.5-year felony?
Well, we really hope it doesn't go that far, Your Honor, but I understand there are scheduling amenities that must be followed. I would note for the record that there are several cases involving Mr. Williams, all or most of them with the victim in this case. I note that the personal protection order, which is pending and is connected to this matter, has been scheduled for September 7th, 2021, with the idea that we would resolve all of these cases at some point before then. In any event, Your Honor, we would ask the court to put this on the trial docket, but perhaps schedule a status conference in the next 2 to 4 weeks. I know that the assistant in charge of this case has been unavailable for consultation, and I am suggesting graciously, and I do mean that, I think that this case is capable of resolution given the intimate connection the family has with the Department of Health and Human Services right now. I would ask the court to order my client's attendance in person at that hearing, and I would ask the prosecutor to consider inviting the victim to be available for consultation in a way that's consistent with her rights under the law. Thank you, Your Honor.
Thank you. Very well, the case will be scheduled for a jury trial. We'll have a final settlement conference on Monday, August 2nd at 9 a.m. The defendant must appear in person at that final pretrial conference.
Thank you very much.
And did you get that date, Mr. Williams?
Yes, sir.
All right. So even if there's some difficulty contacting you in the future, you are fully informed. You have to be here on Monday, August 2nd at 9 a.m. And we'll see you at that time, if not before, sir.
Okay, thank you, Your Honor.
Thank you, Mr. Williams.
Thanks, sir. Stay in touch with your lawyer.
Yes, sir.
And calling,
This is Mr. Tyler.
calling the case of People versus Dominic Ryan Tyler.
Your Honor, just for clarification of the record, this would be a recall in the case because he was called for this. Thank you.
The clerk points out we're recalling the case because he was called earlier and the court at that time didn't cancel his and revoke his bond.
Your Honor, I scheduled for show cause. Scheduled for show
Oh,
cause.
scheduled for a show cause. Thank you, Mr. Moore.
Thank you.
And today is the date and time scheduled for an arraignment. How did you want to proceed in that regard, Mr. Moore?
Thank you, Your Honor. I'm relying on the record that I get created earlier today. There was a lack of communication and a question about whether my client received actual notice of today's hearing. In any event, he is here now. I would ask the court to consider first accepting this plea. He stands mute to the charge. We have received a copy of the information. We waive reading of the information. We continue our waiver of preliminary examination. And we would ask that the June 21st date be converted to a pretrial conference.
Very well. Pleas of not guilty will be entered on behalf of the defendant as to all counts. Because the defendant apparently has appeared, albeit belatedly, the court will rescind its action in forfeiting his bond. And actually, I did not technically forfeit the bond, as his lawyer has pointed out. I scheduled him for a show cause as to why the bond should not be forfeited to occur on June 21. Is that day too early for a pretrial conference, Ms. Ambrositis, or?
No, that'll be fine.
Okay, we'll convert the, we will conduct a hearing then on Monday, June 21 at 9 a.m. in a pretrial conference. Make sure you show up at that time, Mr. Tyler, and make sure you stay in touch with your lawyer. The court will reinstate the bond.
Thank you, Your Honor.
Thank you, sir. Calling the case of People versus Austin Charles Auxier, file 21-6595-FH. Would counsel identify for the record, please?
Good afternoon, Your Honor. Mark West, people.
If it please the court, Scott Moore from the defense.
Today is the date and time scheduled for a status conference in this matter. Does the defendant appear?
Your Honor, the defendant is in the custody of the Gladwin County Sheriff. I understand the clerk has been trying without success through no fault of her own to establish contact with that remote jail.
I have not yet attempted because we've been on the record all morning.
You know, don't contradict me. I'm not.
Sorry.
Listen, hey.
I have not.
I'm not
yet
always
contacted
this
Gladwin
beneficent.
County. If you'd like me to, I can.
In any event, Your Honor, I do believe that the appropriate writ has been served on the Sheriff's Department. I am in the courthouse all day. Certainly will make yourselves available and appreciate the court's indulgence in allowing me to run around and do my shenanigans elsewhere.
Well, thank you, sir.
Mr. Budd would also be in the same circumstance.
They're both in Gladwin County. Gladwin has not called into the courthouse today, and I do believe it's work prepared for all. Mr. Budd and Mr. Auxier.
And I think I'm engaging in an adjournment here, Your Honor, but to roadmap, I believe Mr. Auxier is prepared to enter a plea. And Mr. Budd is ready for sentencing whenever we can bring them in.
Okay. Do you have a time frame?
I can go into the back right now and see if we can contact Gladwin County Sheriff's Department, keep them logged in. If you'd like to either take a quick break. I do have Todd and Mr. Shook as well, but I will be in here, so I don't know how well that's gonna work.
I'd like to attempt to contact Gladwin.
I'll do it.
Thank you.
You see what you're missing? Trapped down there in the dungeon?
I don't mind my little dungeon down here. Some days I miss it.
Oh, yeah.
Not the ones when you're sitting on your deck working on your tan.
Hey, I never do that.
Oh, that's right. That was a weekend.
Yeah.
My fault. I don't think we're on the record. Are we?
No.
Oh, it's all.
No, I shut her down.
All the time. I mentioned out loud that I wanted a park bench. Now there's park bench advertisements all over my Google. I didn't type it in. It just occurred to me.
Where are you going, more coffee?
No, pour this one out. Just making sure.
Calling the cases of People versus Jacob Allen Budd, file 20-6474 and file 21-6581-FH. Would counsel identify for the record, please?
Schumer says, appearing on behalf of people.
May it please the court, Scott Moore for the defense on all files.
Sir, are you Jacob Allen Budd?
He's very small.
That's like the comedy show.
If there are any technical issues, raise your hand in the air and wait.
Calling the cases of People versus Jacob Allen Budd. Are you Jacob Allen Budd?
Yes, sir.
Previously, Mr. Budd, back on April 19, 2021, you appeared in court and in file 20-6474-FH, you pled guilty to the 5-year felony crime commonly known as unlawfully driving away of an automobile. You appear here today to be sentenced in that file. The maximum penalty the court could impose is 5 years in prison. The minimum sentence is discretionary with the court, and at least thus far, your sentencing guideline range is calculated to be 7 to 23 months. On that same file, on April 19th, in a separate file, in file 21-6581-FH, you appeared in court and you pled guilty to the 2-year felony crime of unlawfully of assaulting or resisting or obstructing a police officer. You appear here today to be sentenced in that file. The maximum penalty the court could impose in that file is 2 years in prison, and the applicable sentencing guideline range, at least thus far, is calculated to be 2 to 17 months. On that same day of April 19, 2021, you also appeared in court in file 21-6582-FH, and at that time you pled guilty to the 4-year felony crime of larceny in a building. You appear here today to be sentenced in all 3 files. With regard to the larceny in a building, at least thus far, your applicable sentencing guideline range is calculated to be 0 to 17 months. Although pursuant to People versus Lockridge, the sentencing guidelines in each of these files are advisory instead of mandatory. Mr. Moore, have you gone over all of these reports with your client?
Yes, Your Honor. I met with my client on May 28th at the Gladwin County Jail face-to-face. We did go through the pre-sentence investigation reports at that time.
Is there anything of a factual nature in any of these reports that you want to add to or explain or contradict?
The only thing that I see, Your Honor, is there is a reference to pending charges on page 1 of the CFJ 145. Since the report was written, Mr. Budd has entered a plea on those matters and been sentenced. That's the only change.
Okay, do you want me to treat that as part of your allocution?
Yes, Your Honor. Thank you.
Thank you, sir. Do you have any challenges to the scoring of the prior record variables for the offense variables, or any of the calculation as to the applicable sentencing guideline ranges being 7 to 23 months and 2 to 17 months and 0 to 17 months respectively in these 3 files?
No challenges, Your Honor. The scoring is correct.
And Ms. Ambrositis, on behalf of the people, I pose the same series of questions to you.
Your Honor, we have had the opportunity to review the pre-sentence investigation report. We do find it to be factually accurate. We reviewed the prior sentence variable scoring and the offense variable scoring and find those to be accurate as well.
Mr. Budd, is there anything, sir, you want to say on your own behalf before the court passes sentence?
Yeah, I just ask that Your Honor, the plea deal and end on probation, do what's right.
Thank you, sir. And on behalf of your client, Mr. Moore?
Thank you, Your Honor. The report supports the agreement that was offered by the prosecutor's office. I think that the services that were recommended would be helpful to my client. I also think that, well, it doesn't really matter what I think. I do contend, however, that the recommendation is appropriate, and I ask the court to adopt it.
Thank you, sir. Are there any victims present who wish to speak to the issue of sentencing in any of these three files? The record should indicate no response. And on behalf of the people, Ms. Ambrositis?
We ask that you follow the recommendations in the plea agreement in this matter.
Thank you. Mr. Budd, in order to punish you for what you've done and to deter you and others from committing crimes in the future, but also to give you the chance to rehabilitate yourself, it's the sentence of the court that with regard to all three of these cases and all three of these separate sentences, you'll be placed on probation for a period of 2 years. In addition to all of the statutory terms of probation, you also must abide by all the written terms of your probation order in each file, and those files will be identical except as otherwise indicated. They include but are not limited to: you must not use or possess any controlled substances or intoxicants, and you must submit to alcohol and drug testing on demand, and you must successfully complete any substance abuse or alcohol treatment program to which you are referred, and give up any confidentiality right you have in any such program so that the court may monitor your progress. You must not engage in any assaultive, abusive, threatening, or intimidating behavior, and you must not possess any weapons or copies of weapons. You must not have any contact with anyone whom you know to have a felony record unless you first receive written permission otherwise from the probation agent. You must submit to a search of your person and property without the need of a search warrant. And further, the probation agent does have the legal right to arrest you if he has reason to believe you have violated your probation, or even merely reason to believe you are conducting yourself in a manner inconsistent with the public good. You must abide by a curfew and be in an approved residence from 10 p.m. to 6 a.m. each day. You must not have any contact whatsoever with Leona Lane or be within 500 feet of her residence, school, or place of employment. You must seek and maintain full-time employment and or be enrolled in a full-time education program. You must serve 1 year in the Clare County Jail with respect to each one of these three separate crimes. And with regard to file 20-6474-FH, you will receive credit for 167 days served. With regard to file 21-6581-FH, you will receive credit for 131 days served. With regard to file 21-6582-FH, you will receive credit for 125 days already served. You must comply with DNA testing and pay a $60 fee for that purpose. You must pay $204 in state costs, representing $68 for each of the 3 separate felony convictions. You must pay a crime victims assessment of $390, representing $130 in each of the 3 cases. You must pay $1,500 in court costs, representing $500 in each of the, $500 in each of the 3 cases. You must pay a fine of $1,500, representing $500 in each of the 3 cases. And you must pay court-appointed attorney fees. Do you estimate those to be $1,500 total?
I do not.
Mr. Moore?
I do not, Your Honor. We intend to bill for $550.
You must pay court-appointed attorney fees of $540.
50, Your Honor.
$550.
I'm quibbling over $10. Thank you.
$50 for each one for all of the cases.
That's correct.
$550 total, unless otherwise specified. Those attorney fees will be allocated at 1/3 of that amount for each one of the 3 files. Finally, you must once again serve 1 year in the Clare County Jail with credit for time served for each of these sentences. As previously indicated, the 3 1-year jail sentences will run concurrently to one another.
Your Honor, it was part of the agreement. They would also run concurrently with any sentence that's currently being served.
And also to be concurrent to any sentence the defendant currently is serving.
Thank you.
That will be the sentences of the court, Mr. Budd. It's my duty to inform you that you are entitled to appellate review of your convictions and sentences. And if you are financially unable to hire a lawyer, then the court will appoint a lawyer for you and will furnish that lawyer with the records and the transcripts that are necessary to perfect an appeal. But a request for the appointment of an attorney must be made within 42 days of today's date in writing and sent directly to the court. Is there anything else you wanted to address, Ms. Brubaker?
Thank you, Your Honor. The only thing that I ask is, Mr. Budd, when you are released from the jail, you need to contact the probation department immediately.
All righty.
Okay, thank you.
You're welcome.
Thank you. Is there anything else you wanted to address, Mr. Moore?
No, thank you.
Or on behalf of the people?
No, thank you.
Thank you, ma'am. We'll be in recess in that matter. is, let's see here.
Here's the last one.
I know, but I-
Why all of a sudden does it have an announcement?
It's been doing that lately.
I don't know, it's been doing that.
Oh, I think it's because they were getting sued for people, recording and not telling people they're recording. I think it's a Zoom
What
thing.
happens to the person that logs in after the recording's already started and it doesn't notify them that it's recording?
I think there's like a little icon.
It is, there's a link.
All rise. 55th Circuit Court is now in session. The Honorable Thomas R. Evans presiding.
Good afternoon, you may be seated. Following the case of People versus Austin Charles Auxier, file 21-6595-FH. Would counsel identify for the record, please?
Good afternoon, Your Honor. Mark Webb on behalf of the people.
Please, the court's got one.
Mr. Auxier, would you please raise your right hand to be sworn, sir?
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Could you tell us your name?
Austin Asher.
You may be seated if you'd like, Mr. Auxier. Today was the date and time scheduled for a status conference in this case. Does your client wish to proceed by way of a plea today, Mr. Moore?
Yes, Your Honor, we're prepared to proceed on count one of the amended information, of which we have received a copy. We waive reading of the information in the court and continue our waiver of preliminary examination.
Mr. Auxier, do you understand that according to count one, you are charged with the 10-year felony crime commonly known as possession of methamphetamine?
Yes, Your Honor.
Now, that crime is a felony. It carries a maximum penalty of 10 years in prison and/or a maximum fine of up to $15,000. Do you understand that?
Yes, Your Honor.
Now, there is no mandatory minimum sentence, but unless you are sentenced to more than a year in prison, then the court must suspend or revoke your driving privileges. Do you understand those things?
Yes, Your Honor.
Now, with regard to count one, possession of methamphetamine, you may make any of the following three pleas. First, you may plead guilty if you are guilty, but don't plead guilty unless you are guilty. Second, you may plead not guilty. And third, you may stand mute and say nothing, in which event the court would enter a plea of not guilty for you. Do you understand the three possible pleas that you may make to count one, possession of meth?
Yes, I do, Your Honor.
Then answering to count one, possession of methamphetamine, what is your plea?
Guilty.
Now, sir, do you understand that no one can make any promises for me about what your sentence will be?
Yes, I do, Your Honor.
The court also informs you that if your plea of guilty to count one is accepted, then that means you won't have a trial of any kind, and you therefore would be giving up each and every one of the following rights. The right to have a trial by a jury, the right to have a trial by a judge sitting without a jury if you prefer, the right to be presumed innocent until proven guilty, the right to require that the prosecutor prove you guilty beyond a reasonable doubt, the right to have all of the witnesses against you to appear at the trial, and for you and your lawyer to have the chance to question and cross-examine each of those witnesses, the right to have this court order any witnesses that you might want for your defense to be required to appear at the trial, the right to remain silent during the trial and to not have your silence used against you. But finally, you also do have the right to testify at the trial. And if you choose to do so, then your testimony would be considered in the same manner as the testimony of any other witness. Do you understand all of these rights, Mr. Auxier?
Yes, I do, Your Honor.
And do you understand that by pleading guilty to count one, that means you'll be giving up each and every one of these rights?
I do, Your Honor.
Now, sir, I'm going to ask your lawyer and the assistant prosecuting attorney to tell us what the plea agreement is. And I want you to listen to both of them very carefully. Mr. Webb, what is the plea agreement?
Your Honor, we have filed an amended information, and the court should have a copy, and we've provided a copy to Mr. Warren. And the amended information does not include the second or subsequent drug offender notice that was in the original information. Given that, the defendant will plead guilty to count one, possession of methamphetamine, and in exchange for that, we will dismiss counts 2 and 3 to sentencing, recommend no initial incarceration, and a term of probation, and any restitution to be determined.
Mr. Moore, is that your full and complete understanding of the plea agreement?
It is, Your Honor. The record should reflect that I affirm our receipt of the information. I sent a copy of the plea sheet to Agent Brubaker for record and review. This is a full and complete understanding of our plea agreement. Thank you.
Thank you, sir. Mr. Auxier, did you hear what the prosecuting attorney and your lawyer said the plea agreement is?
Yes, I did, Your Honor.
Did you understand the plea agreement?
Yes, I do, Your Honor.
And do you agree with that plea agreement?
I do, Your Honor.
Has anyone promised you anything beyond what is in that plea agreement to get you to plead guilty?
No, Your Honor.
So, for example, has anyone promised you that if you plead guilty, that this court then would be lenient or light on you in any way?
No, Your Honor.
Has anyone threatened you or your family to get you to plead guilty to count one?
No, Your Honor.
Is it your own personal choice to plead guilty to count one, and are you doing so freely and voluntarily.
Yes, Your Honor.
Now, do you have any questions about what the court has told you?
I do not, Your Honor.
Do you understand everything that the court has told you?
Yes, I do, Your Honor.
And in light of everything that the court has told you, do you still wish to plead guilty, Mr. Oxier?
I do, Your Honor.
Then, sir, drawing your attention back to on or about March 11 of 2020, were you in the county of Clare in Clare County, Michigan?
Yes, I was, Your Honor.
And on that day and at that location, did you knowingly possess some methamphetamine at that time, Mr. Oxier?
Yes, I did, Your Honor.
About how much methamphetamine did you have in your possession at that time?
It was less than a gram.
Okay, but it was a measurable amount, correct, sir?
Yes, sir.
And did you have any legal right or justification or mitigation to possess this methamphetamine at that time?
No, I did not, Your Honor.
But you went ahead and did so anyway, correct?
Yes, sir.
Mr. Moore, are you satisfied that there's a sufficient factual basis to accept the defendant's plea of guilty to count one of the amended information, possession of methamphetamine?
Yes, Your Honor.
Do you agree, Mr. Webb?
Yes, Your Honor.
Has the court complied with the court rule in the taking of this plea, Mr. Moore?
Yes, Your Honor.
Do you agree, Mr. Webb?
Yes, Your Honor.
Very well, in this case, the court has not agreed upon the possible plea or the possible sentence with the prosecutor, the defendant, the defense attorney, or anyone else. The court is convinced that the plea is accurate and has been understandingly, knowingly, and voluntarily made. The plea of guilty is accepted and ordered entered on the records of the court. Sentencing will occur at 9 a.m. on Monday, July 19, 2021. Is there any issue as to bond, Mr. Webb?
No, Your Honor.
Your Honor, not with bond. However, I would point out that my client is scheduled for sentencing on July 7th in the Roscommon Circuit Court. He's already had pre-sentence investigation reports conducted by the Roscommon and Gladwin County Parole and Probation Offices. I understand that it's difficult to get these things done within a month to begin with, but given that most of the work has already been done, I would ask the court to consider asking the Department of Corrections if we could do this on or before July 7th.
Very well, then we'll schedule the sentencing at least tentatively for 9 a.m. on Tuesday, July 6th, 2021. And we'll continue the bond until that date. If it cannot be done by then, Agent Brubaker, just let the court know and we'll let the attorneys know. Otherwise, we'll try to do the sentencing on Tuesday, July 6th at 9 a.m.
Much obliged, Your Honor. Thank you.
Thank you, Mr. Moore. Anything further, Mr. Moore?
No, Your Honor. Thank you.
or Mr. Webb,
No, thank you.
or Agent Brubaker.
No, Your Honor, thank you.
Do you have any additional instructions you wanted to give to the defendant, Agent Brubaker?
Sure, Your Honor. Mr. Oxier, if you do bond out before anyone gets in contact with you before sentencing, make sure to call the Clare County Probation Department.
Okay,
Thank you.
thank you.
Thank you, sir. We'll be in recess in that matter then.
That's everything until 2 p.m.
That's everything until 2 p.m. Thank you, Scott. Thank you, Mr. Webb.
Thank you.
55th Circuit Court is now in session. The Honorable Thomas R. Evans presiding.
Good afternoon. You may be seated.
Charges for both Mr. Wallace, which was not yet connected. For the processing, but we have all the parties for the motion hearing and for the we have Gildersleeve and we also have what's called Sandwich, so whichever case.
Calling the case of People versus Kenneth Dale Gildersleeve. 20-6342-FH. Would counsel identify for the record, please?
Schumer says, Supreme Behalf of the People. Mr. Newman, you're muted.
Unmute. Attorney Scott Newman on behalf of the defendant.
And does Kenneth Dale Gildersleeve also appear?
He does, but he is muted and I don't know if the facility has to unmute him.
Okay.
Yep, there.
Can you hear me now?
Yes, Mr. Gildersleeve, can you hear us?
Yes, sir.
All right, and we can hear you. We appear here today because your attorney, Scott Marshall Newman, has filed a motion to withdraw as your court-appointed appellate attorney. Is there anything you wanted to add to that motion, Mr. Newman?
Yes, it's more or less a motion to vacate because of time restraints. There is no way that I can properly represent the defendant because he has there's been a breakdown in the attorney-client relationship, and he's ordered me not to work on the case. And the time for filing an appeal fast approaches. I believe it's June 15th, and therefore there's no way I could properly represent him.
Well, he seems to have put you in a real bind, and he seems to have put himself in a real bind, because quite frankly, I don't see how any other lawyer is going to get an appeal done by June 13th either. But in any event, you think there's been a breakdown in the relationship to the extent that it's impossible for you to adequately represent Mr. Gildersleeve. Is that true, sir?
Yes, and it's true on his behalf, as he wrote in a letter to you.
All right. So you would like to withdraw for those reasons, correct?
Yes, Your Honor.
Do you have any position in this matter, Ms. Ambrositis?
No.
Okay, Mr. Gildersleeve, I take it you want Mr. Newman to withdraw from the case as well, is that correct?
Yes, sir. As far as the time restraint, though, I want to make it, you aware that I didn't have any dealings except through the mail, very short dealings for 5 months of that 6 months time limit with Mr. Newman. He contacted.
So you're in a hell of a bind then, aren't you?
Yeah, I am.
All right, but you would like Mr. Newman to withdraw from the case, correct?
Yeah, we can't work together.
All right, I will grant that request, and I will sign an order to the effect that Mr. Newman is withdrawing from the case. Now, are you going to be representing yourself, Mr. Gildersleeve? Or are you going
No,
to
sir.
hire a lawyer? Or what is it you want to do, sir?
Well, in my letter and in the motion, I requested that substitute counsel be appointed. And I had actually asked if Sato could be that counsel. I know I don't have a choice, but that'd be my preference. And as far as
All
the
right,
time
well,
limit,
I will appoint a lawyer to represent you, but I want you to be fully aware, Mr. Gildersleeve, that, working with someone is a two-way street. And from here on out, if you have problems with the next attorney, I'm going to be very skeptical about that the attorney is the problem. I'm going to be inclined to look at things that you're the problem. But in any event, I will grant the motion. I will sign an order removing Mr. Newman as the attorney from the case, and I will appoint a different lawyer. And God help you, I certainly hope that you have enough time to, or your next attorney has enough time to file the motions. Good luck to you, sir. Thank you, Mr. Newman, for all your hard work on the case. And thank you, Ms. Ambrositis as well.
Thank you, Your Honor.
Thank you. And good luck to you, Mr. Gildersleeve. You
Your
might
Honor,
need it.
Your Honor,
Yes, sir.
you keep saying that I'm going to have a hard time. Isn't some of the can't I get something from you saying that you'll accept a motion for my issues?
The problem you have, sir, is this. I'm not the judge. I'm not a judge of the Court of Appeals. I'm a judge of the 55th Circuit Court. And so I don't decide for them whether an appeal has merit or not. And I don't decide for them whether an appeal has been filed in a timely manner or not. So you're on your own in that regard. Good luck to you.
Well, I understand that. I understand that, but I'm trying to get back in front of you with the motion.
Well, if in fact there's a mechanism to bring a case back or bring a motion back in front of me, I'll take a look at it. Thank you for being here, sir. Busy in recess.
All parties for Wallace on the chair now.
We do? Okay. Calling the case of People versus Thomas Wolasanowicz, Thomas Allen Wolasanowicz, file 21-00652, I'm sorry, 21-00655-9-FH. Would counsel identify for the record, please?
Joan Besides, bring on behalf of the people.
Thank you, Your Honor. Todd Diedrich appearing on behalf of Mr. Wolsonovich, and I would request a very brief breakout room with Ms. Ambrositis that's available.
Okay. We'll be in recess then, and you can meet with Ms. Ambrositis if she's available.
All right, I'll be in the room now.
Thank you, ma'am.
Mr. Wolasanowicz, I'm gonna go ahead and place you back into the waiting room until the case is recalled, okay?
Yes, ma'am, thank you.
And same thing, Ms. Warwick, I'm gonna place you in the breakout, or in the waiting room as well.
She was here for Gildersleeve.
Oh, she was? Oh, you're right, she did. No, I removed her now. Are we all just in recess right now.
Todd? Calling the case of People versus Thomas Allen Wolasanowicz, file 21-6559-FH. Would counsel identify for the record, please?
Sean Brzezis appearing on behalf of the people.
Thank you, Your Honor. Todd Dietrich appearing on behalf of Mr. Wilsonovich.
And are you Mr. Wolasanowicz?
Yes, Your Honor.
Previously served back on February 16, 2021, you appeared in court, and at that time, you pled guilty to the 5-year crime of uttering counterfeit notes. You appear here today to be sentenced. The maximum penalty the court can impose is 5 years in prison. The minimum sentence is discretionary with the court, and the Clare County Circuit Court Probation Department and Michigan Department of Corrections have prepared a pre-sentence investigation report as well as a sentencing information report. And in those two reports, at least thus far, the departments calculate your applicable sentencing guideline range to be 0 to 11 months. Although pursuant to People versus Lockridge, those guidelines now are advisory instead of mandatory. Do you understand those things, sir?
Yes, Your Honor.
Mr. Dietrich, have you gone over these reports with your client?
I have, Your Honor.
Is there anything of a factual nature in either report that you want to add to or explain or contradict?
Your Honor.
What's that?
Report.
Todd, your computer keeps freezing up.
Okay. When we came for sentencing, we were advised that recovery court was not going to accept Mr. Wilsonovich. So we had been trying to go back to the drawing board about a resolution. This is why it's been adjourned several times. So I think what we have finally come to an agreement with on the plea agreement is that he'd be sentenced to no initial incarceration, that he would be required to obtain a substance abuse evaluation and follow through with any recommended treatment. And that would be the edited version of the plea agreement. Is that correct, Ms. Ambrositis?
That's correct.
All right, and so then the felony conviction would remain on Mr. Wolasanowicz's record moving forward, correct?
That is correct. The dismissal at the end of recovery court would no longer be an option because he was not accepted into recovery court.
Okay, thank you, sir. And with that clarification, then, that's your understanding of the plea agreement, Mr. Dietrich?
It is, Your Honor.
And Ms. Ambrositis?
Yes.
And it's your understanding of the plea agreement as well, Mr. Wolasanowicz?
Yes, Your Honor.
And you wish to accept this offer, correct? And you want to go ahead and be sentenced today, correct?
Yeah. Yes, Your Honor.
All right. Mr. Dietrich, have you gone over these reports with your client?
I have, Your Honor.
Is there anything of a factual nature in either report other than as it pertains to the details of the plea agreement that you want to add to or explain or contradict, sir?
No, Your Honor.
Do you have any challenges to the scoring of the prior offense variables or the prior record variables or the offense variables or the calculation as to the guideline range as being 0 to 11 months, Mr. Dietrich?
No, Your Honor, I do not.
And Ms. Ambrositis, I pose those same questions to you as well, ma'am.
Your Honor, we have reviewed the pre-sentence investigation report. We find it to be factually accurate with the amendments that we made on the record today. We reviewed the prior record variable scoring and the offense variable scoring and find that to be accurate as well.
Thank you, ma'am. Mr. Wolasanowicz, is there anything, sir, you want to say on your own behalf before the court passes sentence?
I just thank you guys for your time and for your cooperation. Give me a chance.
Thank you, sir. And on behalf of your client, Mr. Dietrich?
Yes, Your Honor, just quite frankly, I think Mr. Wolasanowicz, he's kind of drifted off the line that I think he knows he could be on in a bad way, obviously. I think that the discussions I've had with the prosecutor as well as Mr. Wolasanowicz are meant to see if the system can help Mr. Wolasanowicz rehabilitate himself. It's hopeful that he can. It's hopeful that he will take advantage of these opportunities to work with probation, to focus on rehabilitation. Unfortunately, the situation stems from addiction, and he's also had issues in family court with his children. And so things have kind of spiraled out of control for Mr. Wolasanowicz, and I think he sincerely wished it hadn't. I think he sincerely wishes that he had the resources and the wherewithal to correct it himself, but I think it's pretty clear he does not. And so I'm hoping that the probation department will actually work with him, and not saying that they ever work against people, but I think if he has the proper guidance and he puts his foot down and he makes this situation happen, I think he's going to be fine in the long run. But he also is probably going to have a tough go at it initially, at least. And so I think that what the prosecutor is fairly done today is offer an opportunity, at least for him to have that guidance made available through the department as well as the court. And then the rest is really going to be up to Mr. Wolasanowicz. I actually had about an hour-long conversation with him yesterday on the phone about these things. And so I'd asked the court to follow the agreement between the parties. I know Mr. Wolasanowicz is listening, and I know he's paying attention to what I'm saying. And I don't think he's in disagreement with what I'm saying based on our conversation yesterday. This is a young man that needs help. Some people are very self-proficient. Some people are very able to help themselves, and others are not. And right now, even though I think Mr. Wolasanowicz has the potential to be one of those people, I don't think he is right now, quite frankly. And that's why I know he's going to need some hand-holding. And I asked the court to fashion a sentence to allow that to happen. Thank you.
Thank you, sir. Are there any victims present who wish to speak to the issue of sentencing? The record should indicate no response, and on behalf of the people, Ms. Ambrositis?
Your Honor, we ask that you follow the recommendations in the plea agreement in this matter.
Thank you, ma'am. Very well, Mr. Wolasanowicz, in order to punish you for what you've done and to deter you and others from committing crimes in the future, but also to give you the chance to rehabilitate yourself, it's the sentence of the court. You'll be placed on probation for a period of 3 years. In addition to all of the statutory terms of probation, you also must abide by all the written terms of your probation order as well, which include but are not limited to: you must not use or possess any alcohol or controlled substances or drug paraphernalia. You must submit to alcohol and drug testing on demand, and you must successfully complete any substance abuse treatment program to which you are referred by the probation department, and give up any confidentiality right you have in any such program so that the court may monitor your progress. You must seek and maintain full-time employment and or be enrolled in a full-time education program. You must not have any contact with anyone whom you know to have a felony record unless you first get written permission to do so from the probation agent. You must not engage in any assaultive, abusive, threatening, or intimidating behavior or possess any weapons or copies of weapons. You must submit to a search of your person and property without the need of a search warrant. And further, the probation agent does have the legal right to arrest you if he has reason to believe violated your probation, or even merely reason to believe that you are conducting yourself in a manner inconsistent with the public good. You must abide by a curfew and be in your approved residence every day between 10 p.m. and 6 a.m. You must comply with DNA testing and pay a $60 fee for that purpose. You must pay $68 in state costs and a crime victims assessment of $130, a supervision fee of $1,080 to be paid at the rate of $30 per month. But it could be more than that, because if you are on electronic supervision, it will increase to $60 per month. You must pay court costs of $500, a fine of $500, and court-appointed attorney fees. Do you have an estimate, Mr. Dietrich?
Yes, Your Honor, this was a rather lengthy one. It was $2,780.
Court-appointed attorney fees of $2,780. How much of that $5,000 or so do you have available today to pay towards your court-ordered money, sir?
Sir, I don't have any money on me right now, not today.
All right, then you must pay at least $200 per month to be paid by 12 noon on the first day of each and every month, starting on August 1st, 2021, and with a similar amount due by 12 noon on the first day of each month thereafter, until it is all paid in full, but it all must be paid in full by the time you get off of probation. That will be the sentence of the court, sir. I'm not going to incarcerate you here today. It is my duty to inform you that you are entitled to appellate review of your conviction and sentence. And if you are financially unable to hire a lawyer, then the court will appoint a lawyer for you and will furnish that lawyer with the records and the transcripts that are necessary to perfect the appeal. But a request for the appointment of an attorney must be made within 42 days of today's date in writing and sent directly to the court. Is there anything further, Mr. Dietrich
No, Your Honor.
or Ms. Ambrositis?
No, Your Honor.
Do you have any additional instructions to give to the defendant, Agent Coder?
I do, Your Honor, thank you. You need to call Agent Medley at the following number. Do you have something to write down this phone number?
Yes.
989-539-2458. Again, that is Agent Rebecca Medley. Thank you, Your Honor.
Thank you, sir. Very well then, if there's nothing further, we'll be in recess. Good luck to
Your
you,
Honor,
sir.
I'm sorry, does the court have to recall the warrant that it issued earlier, or would the court be willing to do so?
Oh, yes, thank you, Mr. Dietrich. The court will recall any warrant that it issued earlier today and reinstate any bond that it canceled earlier today in this file because of the defendant being late. Thank you. Good luck to you, sir. Thanks, Mr. Dietrich. We'll be in recess.